I may pardon to mention, madam, the matter WPC number 8440/2019. It is almost the pleadings are completed, but the matter is not heard. The lady is working in the state the legal service authority. Is getting not getting promotions because of this matter. This will be next week. Another matter, my lord, Land Acquisition Act. The petitioner is getting overaged. My lord earlier come before my lords. My lord directed to consider the case, but the MCL authority is not considering, and now I'm getting overaged. My lord, this may be taken up next week.
Appeal will receive. Happy New Year inside the court. Item 5.
So wait. When the matter reaches, make it. Yeah.
Supplemental list. Item number 1. Item 2.
Yes.
Item 2.
Passover.
Item 3.
My lord.
What is the personal to order?
Let's
Let's see. There is no delay, so he has not pointed out where he filing.
Not just
IN number 2789 of 2025. This is an application for condonation of delay. The stamp reporter has pointed out that delay in a petition is not pointed out.
So, but this delay is otherwise to be.
The stamp reporting has not been made to that effect. In view of such report furnished by the stamp reporter, the land council for the petitioner does not want to place this interim application. According to the IU, the court was not placed. So IN number 2725. Yes, what is the matter? Are you not ready?
Well,
Huh?
my lord, the present writ petition, the petitioners challenge the order dated 4/1/2024 passed by the learned Central Administrative Tribunal Cuttack Bench in OA number 14 of 2016, thereby illegally quashing the rejection order dated 24/6/2015 and directing the respondents, the present petitioners, to allow higher pay to the applicant while officiating in the post of Senior Superintendent RMS 10 Division as SSRM and pay the said amount within a period of 60 days from the date of receipt of copy of the order. The learned tribunal has not.
Why are you reading that?
My lord.
Why are you reading from your brief?
My lord.
To argue the matter. Oh, wow. What is the illegality committed in the order of the.
My lord, my lord, he had been, while he was in junior time scale, he had been appointed as Senior Superintendent RMS
Come to
Division.
paragraph number 18. Page number 24.
My lord. The applicant had worked in the higher post from 8/6/2004 to 31/10/2006 even though the respondents contend that it was a local level arrangement, but this tribunal is of the opinion that the local level arrangement should be a temporary one and not a continuous one for more than 2 years. The applicant had worked in the post carrying higher pay and higher responsibilities, for which he would have been held responsible for his omission and commission, and thus his claim for higher pay during holding of such post and responsibilities is valid, and the respondents are under obligation to consider the same. However, since the applicant, even though retired from service in the post of Senior Superintendent RMS N Division Cuttack, but he was never regularly promoted to the cadre of senior time scale, and hence retired as junior time scale. That is because they are calculating that once after 4 years staying in junior time scale, then only he will come to senior times. So that calculation is based on their earlier notification. Accordingly, the tribunal, in view of the discussions above made above, finds that the action of the respondents in rejecting the claim of the applicant for higher pay while officiating in the post of Senior Superintendent RMS N Division Cuttack is illegal. Accordingly, the impugned order dated 24/6/2015, Annex 12, is quashed, and the respondents are directed to pay the applicant the said amount within a period of 60 days from date of receipt of the copy.
So, the law laid down by the Honorable Supreme Court has been considered in paragraph number 16, that if somebody is discharging his duty in a higher post, okay,
My lord,
and for a long period, like
Considerable
a
period.
considerable period,
my lord,
then at least he is entitled to get something more, not that which he was getting. So, come to that paragraph number 16, you can find that decision.
my lord, Honorable Affairs Court in
Dharampal
the
case.
case of State of Punjab and another versus Dharampal, observed that the respondent who was appointed as clerk on 22/5/1970 and promoted to senior assistant on 22/9/1980 was given the officiating charge of the superintendent grade 2 wide order dated 9/12/2004, and thereafter he was directed to function as superintendent grade 1 wide government order dated 26/5/2007. He superannuated from service on 31/3/2008. He approached the High Court for grant of benefit of pay scale for the posts of superintendent grade 2 and superintendent grade 1, which was allowed. The Honorable Apex Court held
This is
that
most important, yes.
the Honorable Apex Court held that if a person is promoted to the higher post and or put to officiate on that post with an agreement that he would not claim higher salary or other attendant benefits, it would be contrary to law and also against public policy. Hence, the respondent was relieved from the substantive post and worked in higher post, and the rules do not prohibit grant of pay scale. My lord, but however, the important part here is that the rules do not prohibit grant of pay scale. But in our case, there was already a notification that first he has to work in junior time scale for 4 years, and only then his senior time scale
No,
will
what
be
it
calculated.
says that when you posted him
As
in
senior superintendent,
senior superintendent,
my lord.
so where is that order? Has he stated that no, even though you post me, I will not claim any higher salary?
My lord, on the first instance, he was posted on ad hoc basis. That was on
Yes, 36/2004 to 29/1/2006 for 2 years.
my lord.
So that would be, you see, that is why the Honorable Supreme Court has that it will be public policy. You will post somebody, he will take the higher responsibility, will not pay anything for that. And suppose somebody also take an undertaking, the higher authority or the from the employee concerned, that he will not claim higher salary. That will also against the public policy.
But that is not here. Here is a case where you have given him
Yes.
an ad hoc promotion,
My lord.
directing him to work for a considerable period of 2 years on ad hoc basis. Again, you are making it regular. So, where is the question? It doesn't, purely it fits to the case. Dharampal is absolutely correct. So how do you say that higher responsibility is not taken? He merely on changing the group cadre, you cannot say that the responsibility is reduced. He is working in the same,
My lord,
though the group has been changed.
my lord,
So how does it affect the person who is in the seat? He is working in the same manner
my
with
lord,
the same responsibility. Only thing is that you have changed the group to JTS group.
my
Does
lord,
not matter. But he is in this senior superintendent of post office.
my lord, our only submission is that in page 22, para 12,
Page 22, para 12.
my lord, that the order dated 27/7/1999 was done after Gazette notification dated 18/3/1997, where at clause 3 it was decided that posts in senior time scale cannot be filled on account of officers with requisite years of service in junior time scale not being available.
Then why did you post him in
Therefore, they
that
are
post?
temporarily
If he was not eligible?
You have regularized his service.
My lord,
That you come to paragraph number 18, that is your counter affidavit also filed.
my lord,
If you come to page number 18, just what was pointed out by esteemed brother, 1, 2, 3, 4, 5 lines from the top of page number 18. Impugned order.
my lord,
Since the applicant, pilot,
my lord, has
had worked on ad hoc
JTS
JTS
officer
officer from 30/6/2004 to 29/1/2006 and as a regular officer in the same post of so and so of Cutter from 30/1/2006 to
Till his
30/10/2006 till his retirement.
Yes, yes. Can't prevent him.
So the man has retired, he has worked in a higher post. You are not paying him.
Even otherwise, it is attributable to the employer. Reason being, having come to know that the person is not eligible according to your notification, he has been posted there. Means you find him eligible. Otherwise, so how can you deprive him?
My lord,
It is not a question that somebody has gone on leave and he is officiating.
my lord,
If that is the question, yes, we can say.
my lord.
But you have been posted
And this
there.
eligibility thing has not
Yes.
been there in your counter affidavit.
Exactly. That notification came in 1997 was not there. So in view of the notification, he should not have been posted at all, according to you.
My lord, they're saying the notification is with regard to only the pay.
Exactly. Then a person who will be deprived of a particular benefit, but will be posted there, even if he is not eligible. How can it be? You can't have both the things in your favor.
Anything further you want to know?
No.
Look, this writ petition has been filed by the Union of India, represented through its secretary from DGO Post and Chief Postmaster General, Odisha Circle, challenging the order dated 4/1/2024 passed by the London Central Administrative Tribunal, Cuttack Bench Cuttack, in way number 14 of 2016. The opposite party, number 1, Naveen Kumar Shanapati, filed the aforesaid way, challenging the order of the petitioners in denying him the pay of the post of Senior Superintendent, RMS and Division Cutter, in which he was ordered to work. And accordingly, further prayer was made in the original application, inter alia, for a direction to the petitioners to pay the salary sanctioned to STS Group A post of SSC RM, RMS N division, in which the he was working with a further direction to the petitioners to revise the pension and pay order, pay other pensionary benefits as admissible under law. The case of the opposite party number one is that he had been serving as a senior superintendent post office, Sundargarh division from 5/7/2002 to 26/2004, and then he was transferred and posted as a senior superintendent RMS and division cutter, where he worked from 36/2004 to 31/10/2006 on a temporary basis and ad hoc basis till his retirement on superannuation. Upon not receiving his dues for this duty till his retirement, he made a representation before the authorities for the pay of his post, since the post of SSRM RMS and division is a permanent post in the STS group and carries definite rate of pay without any time limit. He received no response from the petitioners and filed an RTA application to know the status of the representation, application under RTA Act, to know the status of the representation, and then again submitted another representation on 21/3/2012 and 18/9/2012 for the pay sanction to the post of SSRM RMS post. The representation dated 21/3/2012 was rejected, and the petitioner awaited the decision regarding the representation dated 18/9/2012, and he was informed on 18/9/2013 that the statutory rules, as per statutory rules, the promotion of junior time scale officer to senior time scale officer requires 4 years of regular service in the junior time scale officer's post. Thereafter, the petitioner submitted another representation on 18/12/2013, and since no response was received, he approached the Central Administrative Tribunal by filing OA number 624 of 2014, which was disposed of on 14/8/2014 with a direction to the petitioners to consider the representation of the opposite party number one and to pass order within a period of 2 months. And the representation was did not result since did not yield any fruitful result. He approached the Central Administrative Tribunal again a filing, the OA number 14 of 2016. After issuance of notice, the petitioners filed their counter affidavit, and it is stated that the petitioner was working on ad hoc basis as a senior superintendent, RMS and division cutter, and his posting was circle level arrangement to meet the local level requirements, and he was later promoted to junior time scale of Indian Postal Service Group A on regular basis by order dated 13/10/2006 and 13/10 लिखा है 13/10/2006 and as per the Department of Post
13-1, my lord.
13/1
13-1.
31 अच्छा 13/1 तो
13/1
My lord.
अच्छा then
13
typography
he was promoted to JTS cadre on regular basis.
अच्छा
JTS
ठीक
हाँ।
ठीक है ठीक तो 13/1/2006 होता ठीक है it is the further case of the petitioner that that as per the Department of Post memo dated 27/1999, if the post holder has been holding Group A post for 4 years, then the post is deemed to be in JTS, and the post can be considered an STS when the post holder gets promoted to STS grade to DPC after 4 years of service in the JTS post. And since the opposite party number 1 had worked as an ad hoc JTS officer from 36/2004 to 29/1/2006 and as a regular officer in the same post of SSRM RMS and division cutter from 31/2006 to 31/10/2006 till his retirement, he is entitled to the benefits of that of a JTS officer. The opposite party number 1 filed a rejoinder to the counter affidavit filed by the petitioners, wherein it is indicated that the instruction mentioned are not the amendment to the rules concurred by the President of India, and thus those instruction didn't have the overriding effect of the President of India dated कर दिया in department OM number so and so लिखा है paragraph number है ना The London Tribunal, after going through the pleadings and hearing the London Counsel for the parties, came to hold that admittedly the opposite party number 1, while working officiating as a senior superintendent of post offices Sundargarh division on ad hoc basis in JTS Group A cadre, was transferred and posted as senior superintendent RMS and division cutter bracket STS group cadre on 8/6/2004, and he was given regular promotion to the post of JTS Group A cadre on 13/1/2006, and he continued in the post of Senior Superintendent RMS and Division Cutter and retired on 31/10/2006. The taking into account the relevant portion of the FR number FR 11 and FR 49 Roman 1, the and also the ratio let down in the case of State of Punjab and another versus Dharampal reported in so and so. What is the citation that CA number so and so has been given?
Not on finally.
Yes. Paragraph 16 ने लिखा है नहीं, the state of Punjab versus Dharampal लिखा है जी पूराटा, but
citation is not
citation-
employed. I'll find it.
हाँ,
I'll find it.
give it that image.
My lord.
Came to hold as follows. Quote paragraph number 18. It is pertinent to note that in the case of Dharampal bracket Supra, the Honorable Supreme Court has held as follows. Quote paragraph number 16. The relevant FR 11 and FR 49(1) is 49J are quoted here in below. The you have repeated the same thing in your grounds which you have done. The London Council for the petitioners raised the same points which were canvassed before the London Central Administrative Tribunal, but we find that the London Tribunal has rightly taken note of the ratio let down in the case of Dharampal, which is befitting to the fact of this case, and therefore rightly was the order dated 24/6/2015 and directed the petitioners to pay the amount within a period of 60 days from the date of receipt of the amount occurred the higher pay while officiating in the post of senior superintendent RMS and division cutter. Holding that it was the rejection of the prayer was illegal and rightly directed for payment to the opposite party number one, the said amount. We find no infirmity or illegality in the informed order. Accordingly, the writ petition being devoid of merit stands dismissed.
Item 4.
The owners have unauthorizedly occupied the land of the petitioner for the construction of the PMGIS road without paying any compensation. In this regard, madam, he has filed a representation on the ownership to
What is your representation?
the representation is to pay just and fair compensation at the present market rate.
No. According to you, that this particular land belongs to you, or you are in illegal occupation of the land?
Land belongs to me. Ma'am. Annexure 1 is the ROR. Ma'am.
So, where is the there is, if you have
Yes.
mentioned the no land acquisition proceeding has been initiated.
Yes.
Then for what purpose it was what they
For the
did?
public road.
Huh?
Public road which that is PMGSY road being constructed.
PMGSI road state highway to
Prime Minister Grama Sadak Yojana प्रधानमंत्री ग्राम सड़क योजना
state highway ru block border.
SS to block border via Payaboi of Daspana block.
ये रोड टा आपणकर ये ऊपर नहीं चिंती बोली खाली आपणकर आभरमेंट छड़ा था किसी नहीं.
Representation टा consider करो.
So your land has not been affected by this. It is only that the road was passing by the side of your road,
Last 3 years
land.
they have been kept the materials over the plot of the present petition.
No, that is all right. They stacked the material in your plot, but your plot is not affected by this. Only a portion of your reach passing through the land is being damaged. That is all. Which they said to repair, but they did not repair. You know?
So if your plots are not being utilized for the purpose of construction of the road, why compensation will be paid to you?
We have paid for the last 3 years for my plot materials. I could not cultivate my land. That is why I have sustained my lot.
No, the road construction work has already been completed.
Not completed yet.
Then why did you allow him to keep those materials? So it is somebody has suppose a contractor is utilizing it, so he must have taken your permission. You have also mentioned that I have not objected to this. We agreed for the construction of the road. So contractor काम नेला contractor कहला मु ए जिंस पत्र गुडाक आपन को जमी पेटी रखिबी आपन ताको अलाउ करले काम तापर चलला जमी आपन को यूटिलाइज हेनी रोड नबा ऊपर तो जदि भी किछि जिंस रखिछंती जदि आपन राजी हेछंती तो जदि
last 3 years
डैमेज जदि चाहिबे contractor संगे जदि किछि एग्रीमेंट हेछि ताले सेटा आपन एग्जीक्यूट करिवे व्हाई दी Writ will be maintainable. Why will you direct the collector to interfere and dispose of your representation? What the collector has to do? Contractor ଆପଣଙ୍କର ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା ହେଲା, ଆପଣ ରାଜି ହେଲେ ସେ ଜିନିଷ ପତ୍ର ଆପଣଙ୍କ ଜମି ଉପରେ ରଖିଲା, ତାପରେ ରଖିକିନି ରୋଡ କନଷ୍ଟ୍ରକ୍ସନ ଯେମିତି କରିବା କଥା କଲା, ତ ଇଟ୍ସ ଏ ମ୍ୟାଟର ବିଟୱିନ୍ ୟୁ ଆଣ୍ଡ କଣ୍ଟ୍ରାକ୍ଟର। ତ state कौन ପାଇଁ ଆପଣଙ୍କୁ payment କରିବ?
Collector is the appropriate authority,
हाँ।
land acquisition.
land acquisition କଣ ହେଇଛି?
private dispute
private dispute ହେଲା, କଣ୍ଟ୍ରାକ୍ଟର କୁ ଆପଣ ଆଲାଉ କଲେ ଆଣିକିନି ଧର ସିମେଣ୍ଟ ରଖିଲା ଆପଣଙ୍କ ଜମି ଉପରେ, ଯେ ଦିନ ପର୍ଯ୍ୟନ୍ତ କାମ କାଲି ଆଣି ବାଲି ଗଦେଇବ, ଗୁଡି ଗଦେଇବ, ଆପଣ ତାକୁ ଆଲାଉ କଲେ, ଲେଖିଛନ୍ତି ମଧ୍ୟ वी एग्री, ତାପରେ କମ୍ପେନସେସନ ଆପଣଙ୍କୁ ଷ୍ଟେଟ କାହିଁ ଦବ? This writ petition has been filed by Arjun Sahu with a prayer for a direction for payment of due compensation to him for illegal occupation of the land by plot number 152, area Ekorsun 530 decimal, corresponding to Khata number 43/2, plot number 157, area Ekorsun 150 decimal of land, and plot number 158, area Ekorsun 560 decimal of land, corresponding to Khata number 20 of Mouja, Dugudi, recorded in the name of the petitioner for construction of public road, that is PMGSY road from SH to block border via Oibadi of Dasapalla block, bitumen road 3.800 km, concrete road -1.500 km. The Land Council for the petitioner submitted that the petitioner has submitted a representation before the collector and district magistrate Nayagarh, opposite party number 2, for payment of compensation for 3 years, that is 2022-23, 2023-24, and 2024-25 for damage of paddy crops and repair to the damaged crop field, etc. on 29/1/2025, and he has not received any response from the opposite party number 2, and therefore necessary direction may be issued for disposal of such representation. However, on perusal of the representation, we find that the road in question has not been taken on the land of the petitioner. And it appears that during construction of the road, the contractor put some material over the land of the petitioner. However, the petitioner agreed to the same, and therefore it is a nature of a private dispute between the petitioner and the contractor if he has not paid anything to him, and thereby petitioner has sustained loss, and therefore we are not inclined to accept the submission made by the Land Council for the petitioner for a direction to the opposite party number 2 to dispose of the representation under annexure. Accordingly, the writ petition being devoid of merit stands dismissed.
Item 5.
Yes?
May I,
What
on behalf
is
of
the
both
matter
of us,
about?
may I-
Let them serve a copy, my lord.
କଣ
Let-
ଅଛି ଏଥିରେ? ଆପଣ ପ୍ରେୟାର କଣ? ଆପଣ କେସ୍ କଣ କରିଛନ୍ତି? ରିଟ୍ କାହିଁ ଅଛି? କିଛି ତ ବୁଝା ପଡୁନି।
Well, on behalf of Pujo Sunadas, may I taken up next week, ma'am.
The
somebody
prayer
is
is
standing in
that
the
the direction to the opposite party, particularly opposite party number 4, to take the rest part of the hall plot number so and so, and to allow him the financial assistance of the said plot.
It was
But
filed.
the East Coast Railway is a party that didn't serve the copy of the same. We don't know what is the case.
Well, on behalf of Pujo Sunadas, may I taken up next week, ma'am. Yeah, out
Mr.
of
Pari, what do you say?
But it is a East Coast
Well,
Railway is there. Manager East Coast Railway name is there. Purchase. But we didn't receive the copy of the same. They
Acha.
didn't serve the copy.
Yes, Land and Council for the petitioner serve a copy, and you are seeking for adjournment. We are adjourning the matter, but serve a copy because Mr. Pari is supposed to appear for opposite party number 1, right? Mr. Pari,
Madam.
Solicitor General submits that he has instruction to appear for opposite party number 1, East Coast Railway, and he has not received the copy of the writ petition.
1 and 4 also.
1 and 4.
Deputy Chief Engineer
Deputy
is
Chief Minister, 1 and 4, right? 1 and 4. Land and Council for the petitioner submits 6 for an adjournment. Put up this matter. What is up for In the meantime, the copy of the writ petition be served on the Land Council for the Union of India. Yes.
Item 6.
The petitioner filed this petition challenging the complete inaction on the part of concerned authority, thereby not appointing the petitioner under rehabilitation and resettlement scheme, being a land scheme. Admittedly, his land has been acquired, and Annexure 1 is the proof of acquisition. It was recorded in the name of Akuro Amanta, who is the grandfather of the present petitioner. And thereafter, in spite of several retentions, several requests made by the concerned the present petitioner as well as his father, the authority didn't take any action in this regard.
No, this when the land was acquired.
Land was acquired in the year 2014, May. 2014,
Yes.
Annexure 1 indicates.
This is not a document of 2014.
Yes, 5/8/2014, Annexure 1, page 13.
Page
13, 13, man.
data code ଲେଖା ହେଇଛି କହିଲେ?
Last ଗୋଟେ signature ଅଛି, ଦିଟା signature ରେ ଲେଖା ହେଇଛି 5/8/2014.
ଆମ ଏଇଟା ହଉଛି verified and found to be correct ବୋଲି ବୋଧେ ଇଏ ହେଇଛି, ସେଟା ଆମର true copy type ର ଦେଇଛନ୍ତି। ଏପଟରେ ଯୋଉଟା signature ଦେଖନ୍ତୁ,
ଆଜ୍ଞା,
ଯୋଉଟା
ସେଇ
ସ୍ୱତନ୍ତ୍ର ଭୂ ଅର୍ଜନ ଅଧିକାରୀ, ସେଟା ଗୋଟେ କଣ ଆଉ ଗୋଟେ ଡେଟ୍ ଦିଆହେଇଛି ନା ସେଇ 5/8 ଲେଖା
5/8, man.
5/8/2014.
Yes.
So this Akulo Amanta is
Yes, ma'am.
your grandfather.
My grandfather.
So he is no more.
He is no more.
And what about the legal heirs of that Akulo Amanta?
Legal heirs of the Akulo Mahanta have given Annexure 4 at page 25. Ranjan Kumar Amanta, the son of Akulo Mahanta, Gauracharana Mahanta is the son of Akulo Mahanta. This is to certify that the person
Okay,
specified.
So many persons are there.
Yes, ma'am.
So why you have come for claiming compensation? What about the others?
Others, my lord, they have not read. My lord, I have completed BBA, and others have they have
Can't
consented.
made parties.
Why have you not made them party?
But they have absolutely no
No, no, how do
content
you say-
about my
How do you say so?
candidature.
They are entitled if that land of Akula Amanta has been acquired and no compensation has been paid.
No,
So-
compensation has been paid.
Then what?
I claim that
Other rehabilitation package.
yes,
So
Under
other
what?
rehabilitation package means what type of package?
job by
Where is that? Where is that? Under this,
condition annexure paragraph scheme itself. I have not read the scheme,
No. Scheme.
Scheme.
but I have indicated that
No.
paragraph 6
scheme
you
has
will
to be there.
shall have
Out of
glance.
that scheme,
वो स्कीम रे प्रोविजन अच्छी कि नहीं
Similarly, persons have been appointed by law. Recently, in the year 2025, I have indicated in
you
my
produce that scheme for
scheme manner with the NALCO.
yes.
NALCO, they have got the scheme.
No, that there must be at the time when this.
That is admitted fact. There is absolutely no dispute about the giving job for acquisition of
If
land.
that is so, then where is the question of dispute? You make an application and they'll give it.
I have made the application.
Then
I
they
have
should
made
give
the
it.
petition.
Yes.
But they didn't
So-
consider my candidature.
That's you have to show
Even
the scheme.
open advertisement, I have also applied.
No,
That
not
is
right.
good.
You see,
That is altogether
when
different.
so many persons are the legal heirs,
My
you
lord.
are excluding all of them, and you are coming, and somebody might have
Yes.
told you that you get an order from the High Court, the rest thing will be done by you. That is how you have not made them opposite party.
I will file affidavit of all legal heirs so that they have no objection.
No, you
If
have
the-
them make parties.
First of all, you make them parties.
Then
Number to show that scheme, then
Yes.
we will see that. Lekhondu, the writ petition has been filed with a prayer for a direction to the opposite parties to appoint the petitioner as per his qualification under the Rehabilitation and Resettlement Scheme within a stipulated period. It is the case of the petitioner that the lands of
his grandfather.
the grandfather of the petitioner, namely
Akula
Amanto, in village Pulado,
Pular.
under Khata number 21 and plot numbers 2124 and 2144, been acquired by the NALCO authorities.
Narcos.
For what purpose?
For purpose of
Petition likhiji, petition for the purpose of establishment of NALCO.
Yes.
And no compensation has been paid to the grandfather.
Compensation
Though compensation has been paid to the grandfather of the petitioner, but as per the scheme, even though employment is to be given under the Rehabilitation and Resettlement Scheme, but the same has not been given. The petitioner has not only filed the documents relating to the acquisition of land, but also the record of right. However, we find that the Akula Amanta, as per the submission of the Land Council, Akula Amanta is dead, and the legal heir certificate which has been annexed to the writ petition as Annexure 1 indicates that Annexure 4 indicates that there are 9 legal heirs, and the father of the petitioner, namely Ranjan Amanta, is one of the legal heirs. The petitioner has not arrayed any other legal heirs as parties to the writ petition. Moreover, the scheme under which the petitioner is claiming appointment in the service is also not annexed to the writ petition. Land counsel for the petitioner seeks some time to make necessary amendment to the writ petition for taking steps for making necessary amendment to the writ petition, incorporating the names of the other legal heirs, and also to produce the relevant scheme of the NALCO relating to giving appointment to the person whose or the land has been acquired for the safe purpose. Put up this matter on your account.
The minimum 15 days max.
2 weeks time. Put up this matter after ensuing summer vacation. Yes.
Item 7.
Your Lordship, I am for item 7.
Yes. What have you mentioned in your affidavit?
I have mentioned the name of the petitioner, the name of the K-pota holder, relationship of the K-pota holder with the petitioner, hata number, plot number, area, and number of existing trees on that plot.
Each of them have different colors.
Why have you combined them together in
Because,
filing this writ petition?
as per Annexure 10, it is a common order by the collector. Annexure 10.
Common order maybe because the land is different and the area is different, and so it is not a public interest litigation. So if you are your prayer is very that you are entitled to get certain relief, so it should
Your
be.
Lordship, Your Lordship, as per your Honor's order dated
No, you have
24th.
filed, but after verification, it is your case that compensation amount has not been paid to the petitioner for their K-form land, and those lands you have those are forest land, and
Both
some
K-form and enclosed forest land.
okay.
K-form land and enclosed forest land, and the collector in his rejection a common ground that the K-form he has not found the K-form in the Tahsil office. It has been elaborated in your order
No,
number
it's
1.
all right. If you have got these documents with you now, You can approach
No,
the
yeah.
collector for reconsideration because the
No, no.
collector himself said, and Tahsildar also reported
Yes.
that
No, no,
those
sir.
things are not available. So if you are now having those documents with you, you can produce the same
Yes,
before
sir.
the collector Dhenkanal for
You're-
reconsideration.
No. We have given the Xerox copies, and the collector has mentioned that we have given him the Xerox copies. He is not accepting the Xerox copies. And
No.
NHRC, as per your order number 1, NHRC on 11/7/2014, NHRC has told that the documents are with RI office.
53% they are receiving the amount out of the 46. And
RI office.
Duplicate document.
Yes, that is why he is.
ସେ ସେମାନଙ୍କ ପାଖରେ ଅରିଜିନାଲ ଥିଲା ସେମାନଙ୍କୁ ଦିଆହେଇଗଲା ଏମାନଙ୍କ ପାଖରେ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ନାହିଁ ତେଣୁ ସେଗୁଡା କଣ ଆଣିକିନି ପ୍ରଡ୍ୟୁସ କରିପାରିଲେନି ଜେନୁଇନ ପଟ୍ଟା ଯୋଉଥିପାଇଁ ତହସିଲଦାରକୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଲା ସେମିତି କିଛି ପଟ୍ଟା ଫଟା ଇସ୍ୟୁ ହେଇନି।
ସାର୍ ସେମାନେ ସେ ଯୋଉ ମାନଙ୍କୁ ବି ଦେଇଛନ୍ତି ସେମାନଙ୍କର ବି କିଛି ସେମାନେ ସମସ୍ତଙ୍କର ଅରିଜିନାଲ ପଟ୍ଟା ଗୁଡା ନେଇଗଲେ ସେଇ ଟାଇମରେ। ସେ ଗୋଟେ
ଅରିଜିନାଲ ପଟ୍ଟା ନାହିଁ ବର୍ତ୍ତମାନ ଆପଣ ଯାହା ଡକ୍ୟୁମେଣ୍ଟ ଫାଇଲ କରୁଛନ୍ତି ସେଥିରୁ କିଛି ଖାଲି ଦେଇଛନ୍ତି ଏଇ ପ୍ଲଟ ଗୁଡାକ ପାଇଁ ବଟ୍
ସେମାନେ ବର୍ତ୍ତମାନ ବି ସାର୍ ସେଠି କାଜୁ ଗଛ ଲଗେଇକି ସେଇଥିରୁ ସାର୍ ଲାଇଭଲିହୁଡ ଅଛି ତାଙ୍କର। କାଜୁ ଗଛ
file individual petition before the authority for reconsideration.
ଦିଆ ହେଇଥିଲା ସେମାନେ ପାଇଲେନି ବୋଲି ରିଜେକ୍ଟ କଲେ।
Petition has been filed.
ସାର୍ ସେମାନେ ପାଇନାହାନ୍ତି ସାର୍ ପ୍ଲିଜ।
Sir, please wait.
As per the order dated 24/3/2025, an affidavit has been filed by the petitioner indicating the details of the name of the K-Pata holder and a relationship of the petitioner with the K-Pata holder, the khata number, plot number, area, and the number of existing trees on that land. The copy of the same has also been furnished to the Land Council for the state. We find that the compensation which was claimed by the petitioner was torn down by the collector on the ground that they could not produce the genuine and original K-Pata at the time of hearing. And even the Tahsildar L.O. Gondia reported that there is neither any K-Pata nor any record/document relating to the said K-Pata available in the Tahsil office. And further that the sharecroppers are not entitled to get compensation as per RR Policy 2006. It is the contention of the Land Council for the petitioner that 22 persons have given the benefit and there was no reason on the part of the collector Dhenkanal to reject the claim of the petitioner. However, we find that those persons who have received the compensation were having original patta with them and those were verified and that therefore the relief has been granted to them. Since the petitioners have no such document with them and even on verification from the office of the Tahsildar also no document could be found. That is how the claim of the petitioners were rejected. If it is open to the petitioner to approach the collector Dhenkanal once again by filing authenticated document claiming compensation, which will be adjudicated in accordance with law. Accordingly, the writ petition is disposed of. Yes.
Time period.
File your claim.
Time bound.
Yes, you file your representation for the petitions first. Yes, next.
Item 8.
May I tell also? Madam President, petitioner is a landless person. This is the third time he has approached before this honorable court. After Kho notice was issued, the revisional court rejected the prayer of the petitioner. Annex 5, page 21. After rejected the revisional court, then he approached before this honorable court, page 17, in WPC number 5537 by 2015. Whereby this honorable court directed under OGLS Act is pending before the competent authority. This could dispose of the matter, simply observing that the proceeding before the OGLS authority shall be disposed within a period of
Your
2
matter
months.
was originally for under the OPL Act,
OPL Act.
Prevention of Land Encroachment.
Yes.
So there you have lost.
Revisional court, I lost.
So ultimately you have lost.
There
All right. So you have been directed to be evicted. Then
I approached this honor court in
that is different.
In WPC number 5537/2015, page 17.
Right.
Whereby this honor court directed if the application is pending before the competent authority, that can be disposed of in accordance with law.
Application under different OGLS Act.
OGLS Act.
So whether that was pending at that point of time?
Yes, madam. Pending.
Where is that application?
Annex 7, madam. Page 25.
Where is your earlier application before this court?
That is the page 19.
Where is page 19?
Page
no,
19.
That is order.
That the clearly submitted that the land belongs to Smosan.
No, OGLS application that this is dated application dated 5/2/2002.
Since then it is pending. Since then it is pending. I approached 2 times.
So for settlement of land, you can have a application in accordance with the provision. And you intend the land which is under your encroachment to be settled in your favor.
Yes, ma'am.
How can it be?
Because
How can it be?
I am a land as per rule section 4.
All right.
The reservation.
Did you no? What is the ground on which this has been rejected? What is the extent of land you are under encroachment?
1 decimal.
Where it is?
Moja.
No. See, the nature of land is to be seen. All the land which is under encroachment cannot be settled in your favor. Suppose it's a land occupied in a POS area, which is needed for the public purpose. That cannot be settled in your favor. So, your OGLS has to be taken in a different footing than in OPLE.
ଆପଣ ଗୋଟେ ଶ୍ମଶାନଟାକୁ unauthorized encroachment କରିଛନ୍ତି ଆପଣ କହୁଛନ୍ତି ମତେ OGLS application ସେ land ଟା settle କରିଛି ସର୍ବସାଧାରଣ ଜାଗାଟା ଶ୍ମଶାନକୁ ମାଡ଼ି ବସିକି ରଖିବେ ତାକୁ ମତେ settle କରିଛି ଆଉ ଶବ ପୋଡାପୋଡି କୋଉଠି ହବ
ନା ସେଠି ହଉନି ମୁଁ ଜାଣିଛି
ଜାଣିଛନ୍ତି କଣ
it is identified area.
Identified area ହଉଛି ଏଇଟା ହଉଛି ଶ୍ମଶାନ ଆପଣ ତାକୁ ଏକ ତ unauthorized occupation କଲେ ତା ଦେହରୁ ସେଠୁ eviction ହେଲା ଯେମିତି ହେଲା ସେଠୁ OGLS ରେ ଗୋଟେ application ଦେଲେ ମତେ ଗୋଟେ ଶ୍ମଶାନଟାକୁ ମୋତେ ଦେଇ ଦିଅନ୍ତୁ how can it be possible
with great respect madam because some samsan କିନ୍ତୁ ସେଠି ଦୋକାନ ବଜାର ସବୁ
ସେ ହେଇଗଲା ବୋଲି ଆପଣ କରିଦେବେ ସର୍ବସାଧାରଣ ଖାତା ନମ୍ବର 843 ଅଛି ପୁରା ସେଟା
ଯଦି ନହେଲେ my lord I only pray my application which is pending considered as per law. That is my prayer.
No. For as if you are a landless person, you have every right to make an application for lease of land.
I am a landless person.
All right.
ଦେଖିବେ ନା suitable land ଦେଖିବେ ଆପଣ ଯୋଉଟାରେ particular ଏଇ ଜମିଟାକୁ ଯୋଉ ମାଗୁଛନ୍ତି that is the problem.
As your lordship.
You file another application in accordance with law. But this particular land, because the problem is that you have mentioned this Monsana land to be settled in your favor. That cannot be done. So,
any application I will make that will consider.
Yes.
The writ petition has been filed by the petitioner Saroj Kumar Roy for a direction to the Tahsildar Tangi, opposite party number 4 to settle the land of Mouja Nandapada, plot number 754, khata number आगे खाता नंबर नहीं है खाता नंबर 843 एरिया 84210 decimal in favor of the
non-poda not nondopoda non-poda NAFPADA
in favor of the petitioner. It appears that the petitioner encroached a piece of government land, the aforesaid land, which is the government land, and the kisam is smansana, for which Tahsildar Tangi passed an order of eviction in encroachment case number 3 oblique
10,
10 na 18 এটা
13,
3/13-14.
13-14. And the petitioner challenged the said eviction order before this court in WPC number 4848 of 2014.
No, 5537/2015.
লেখা আছে
প্রথম এটা করতে হবে। আগে, sorry.
And this court disposed of the writ petition, giving liberty to the petitioner to file an appeal before the appellate authority. Accordingly, the petitioner filed the appeal before the sub-collector Khurda, and the said appeal was dismissed. And
Dismissed on
then the petitioner filed OPLE revision case number 11 of 2014 before the collector and district magistrate Khurda. And after hearing the parties and the perusal of the case record, the collector found that the petitioner has encroached this Mansan Sarvashadharana land and used the same for commercial purpose, and therefore was of the view that the courts below rightly passed the orders of eviction as per the act and rules, and there is no irregularity and illegality in this said order, and accordingly the revision petition was dismissed by the order dated 13/3/2015. The Learning Council for the petitioner submits that the petitioner submitted an application for settlement of land under OGLS Act on 5/2002, and the said application has been annexed to the writ petition as Annexure 7, but no action has been taken thereon.
That has not been stamped. But
We find that there is no proof that this particular document under Annexure 7 has been submitted on 5/2002 before the Tahsildar Tangi in the district of Khurda, because there is no endorsement of the Tahsildar to have received the application.
nor any lease miscase has been nor any lease miscase.
Nor any lease miscase has been registered. Moreover, the very same plot, which was the subject matter of the eviction proceeding, has been mentioned in the application for settlement. Therefore, we are not inclined to pass any order in this writ petition directing the opposite parties to consider the application for settlement of land. Stop. At this stage, the Land Council for the petitioner submits that the petitioner may be permitted to file a fresh application for settlement of land in accordance with law, and the authorities may be directed to consider the same. It is open to the petitioner to make an application in accordance with the provision of OGLS Act, for which you are expressing no opinion, and however, this writ petition being devoid of merit stands dismissed.
Item 9.
Yes.
Disposal লিখে দিন। Disposal লিখে দিন আগে।
dismiss तो हला आपको prayer थिला application consider करिया को आपको जमी दे दो कौनसा जमी हमें देलुनी आपको dismiss लेके वो dismiss out a fresh application कर dispose
I'll only frame it.
dispose of how ठीक है next
May I please, Lords? Item 9. This is the matter of the monetary compensation under the provision of rights to fair compensation and transparency of land action, realization and resettlement Act 2013. One Damu Bhatra, who is the opposite party number 5 in this writ petition, filed in the year of 2019. Application number 11,069 of 2019 was disposed of.
No, your prayer is to recall a particular order which is passed in a writ petition.
Yes.
You have to file an interim application there or another writ petition. The council, I am reading your prayer to recall the order dated 13/4/2013 passed in WPC number 6707 of 2021. So whether an order which is passed in a particular writ petition which has already been disposed of, that order can be recalled by filing another writ petition, or an interim application is to be filed in the said writ petition showing the grounds of recall. This writ petition has been filed for a prayer to recall the order dated 13/4/2023 passed in WPC number 6707 of 2021, which has been disposed of as per order dated 13/4/2023. After arguing for some time, the Land Council for the petitioner seeks permission to withdraw this writ petition to file appropriate application in the disposed of writ petition to recall the order dated 13/4/2023. Accordingly, the writ petition is disposed of. Yes.
Item 10.
Now, just have a glance for my list of dates here. Small list of dates.
कौन है जी?
Just have a glance over the list of dates here.
List of dates
Right.
in the date chart.
Dates. Small date chart you know. May 2011, Section 4(1) of Delhi Act was issued for acquisition of land at Betavar Sundargarh for construction of ultra mega power plant project in respect of Pal Khata number 62, area 4.49, Khata number 63, area 12.
You are challenging a particular order passed by the London Senior Civil Judge Sundargarh in LAR case number 314, 315 and 316 of 2013. A common order was passed and it appears that the petitions was rejected. So there is no alternative remedy. Huh? LAR case
compensation has been granted.
Just a minute. You show us the provision that there is no alternative remedy to challenge the order of the special senior civil judge.
No, what is your claim here?
Case is pending before this bill.
Just submitting it. My lord, the collector made a reference on Section 30.
Yes, that is true.
Therefore, the civil judge senior division
Adjudicated the matter. Yes, and awarded.
No award has been passed.
Dismissed it.
No, my lord. Award was passed by the state government. But it
no, because it was not accepted by you. Matter was sent to the collector. He referred it. Now LAR has been adjudicated and dismissed.
No, the dismissal.
Then what is that?
But I have filed an application in the pending proceeding that the admitted dues may be released. And all the petitions, separate applications have been filed by all the petitions. This admitted our amount may be released, and those which are dispute, it may be adjudicated.
No, you are party in the LAR or not?
Mine.
You are party in the LAR.
Party in the LAR. I explain. I am the opposite party. in that LA reference case which has been referred to the civil justice union part.
Civil.
My lord, impugn order
Writ petition is Latika Patel, Ramani Patel, Minna Patel. All the petitioners.
My lord.
They are the petitioners in LA.
There are three references: LA 314, 315, and 316.
Right.
In 315, Latika Patel and some others are the parties, and some other. But in 314, 15, 16, all the petitioners are the parties.
How can we know it? Because this particular order which you have annexed as annexure 2, it indicates only one name as the in the petitioner and 4-5 names in the opposite parties: Sarojini, Sisiro, Latika, Ramani, Minna, and Manjari. But in this writ petition, we find that there are as many as 11 persons.
Just page 28. Page 28. 27 is the impugn order. Page 28, first para, the law in civil described this order arises out of three petitions, such as petitions dated 22/11/2023 filed by the opposite parties, namely Latika Patel, Ramani Patel, Meena Patel, Manjulat and Manjari Patel, Nanda Kishori Naik, Subhas Patel, Ghasiya Patel, Ubha Patel, Bharati Patel, Parameshwar Patel, and Dharmesh Kumar Patel through their power of attorney Dharmesh. And petition dated 28/11/2023 filed by the opposite parties, namely Hare Krishna Patel, Latika Patel, Savitri Patel, Lalita Patel, Savitri Patel, Swarupa Patel, Gokula Chandra Naik, Chaya Naik, Jagdish Chandra Patel, Chandramani Patel, Utkalamani Patel, Taposini Naik, and Vasanthi Naik. And petition dated 8/4/2024 on behalf of some of the legal heirs of Sadanand.
So why these petitions were filed?
All these petitions were filed. Well, second part. All these petitions.
No, where is those petitions?
Petitions your lordship start from page 31 annex 3.
Those are the three petitions.
Those are the petitions your lordship.
What is the prayer in the three petitions which were rejected?
My lord, the prayer is there. Well, page 35 your lordship just a prayer for
Rate an amount of rupees one so may be released in favor of. So it is like an interim prayer.
It is
Now why it has been rejected? What is the ground?
And other petitions have been filed. It is also page 37 annex 4 and annex 5.
It's all right. So during pendency of that LAR proceeding, you filed a petition to release a particular amount in your favor. That petition, three petitions were rejected. Come to the reason why what has been given by the senior civil judge.
Before that reason, your lordship, second paragraph of the impeached order, page 28, your lordship, just a glance. How I am claiming that how they admitted views, your lordship. In this case, shall I read the second paragraph?
Yes.
In this case, the special LAO had made three separate references, and the references are brought together as the parties. And subject matter are said. On perusal of the case record, it is found that the challan number 41, 42, and 44, dated 37/2014, were submitted in this court. By letter number 5133, dated 31/7/2002.
That is all. The order, relevant portion. The very far
reasoning.
The reasoning is that since one party is claiming that previous alienation were made by the parties will affect their share over the compensation amount, it cannot be said that the amount of compensation is undisputed. An undisputed share can be released in favor of the parties on the basis of their petitioner only when there is no dispute regarding the amount claimed by them. But when there are rival claims by the different branches over the compensation amount, it cannot be said that the compensation amount is undisputed. That is how the petitions which were filed to release the amount during pendency of those are rejected. So what is the illegality in that?
Why your lordship I am saying this is illegality? An undisputed share can be released in favor of the other on basis of that petition only when there is no dispute regarding the amount claimed by them. And all these petitioners against whom the award has been passed, all of them have filed the petition, your lords. They have annexed all these petitions. And nowhere in this petition they are disputing it.
No. Then
so far as the khata number 45.
Then what basing on what the LAR case has been adjudicated? What was the dispute?
That's why paragraph There are 41, 42, 43, 44, 3 challenge here. 41, 42, it is disputed because the land by virtue of
So have
41,
you filed
42,
joint affidavit before the court?
my lord.
You have filed joint affidavit
My lord,
that you have no dispute.
I have no dispute so
Huh?
far as the challan number 44
No,
is
no,
concerned.
that you cannot claim in part, no?
Because,
How can you? It is taken together.
because, your lordship, 41, 42, the land has been alienated to a trust, your lordship. So
And
we
after
are
all, it is
questioning
a case of the year, suppose 2013,
13.
and if it is pending, we can direct for
Yes.
expeditious disposal, that's all. If the
Okay.
parties have already entered appearance,
Appearance filed by
or WPC number so and so, this writ petition has been filed by the petitioners challenging the order dated 10/12/2024, passed in LA reference case number 314, 15, 16 of 2013, and for a direction to the Land and Civil Judge Senior Division Sundargarh to release the undisputed compensation amount awarded in respect of Khata number 63, which has been referred to the court by the special LAO by challan number 44. On perusal of the impugned order, it appears that the Land and Civil Judge Senior Division, Senior Civil Judge Sundargarh has pleased to observe as follows. ये जो पेज नंबर 30 रे अच्छी लास्ट seems one party claiming that ସେଇଠୁ ଲେଖିଦେବେ up to without any cost. Say, for example, petition are dismissed once. So the Land Council for the petitioner submits that the observation of the Land Senior Civil Judge Sundargarh that the compensation amount is disputed is not correct. In fact, a joint affidavit has been filed by the petitioners. However, the joint affidavit copy has not been annexed to the writ
3, 4, 5
petition.
pillars.
That is not the joint affidavit. That is a copy of the petition in which you are claiming.
Yes, yes.
So be that as it may, since we find no illegality or impropriety in the impugned order, however, the LA reference case is of the year 2013, and it is stated at the bar that the parties have entered appearance and the pleadings are complete. We direct the Land and Civil Judge Senior Division Sundargarh to expedite the disposal of the LAR case number 1, so preferably within a period of 6 months from the date of receipt of the certified copy of the order. Yes.
Item 11.
In this case, the land with house of the petitioner has been acquired by the opposite department to for extension of NS 220 mile. And the compensation awarded in favor of the petitioner. But after receiving the award, they found that the house of the petitioner has been valued in
House of the
It has
petitioner?
not been valued.
minor, in very low amount. That's why
So it is a case of improper valuation.
Yes.
So you are the alternative remedies there.
no minor.
You say
In this, your lordship in the earlier application filed by out of 4 villagers, your lordship directed the state council to take instruction in the 1471 of 25.
ଆପଣଙ୍କର ଏଇଟା ନ୍ୟାସନାଲ ହାଇୱେଜ ଅଥରିଟି ତ ତ ଆପଣ ଗୋଟେ ଆମାଉଣ୍ଟ ଆପଣଙ୍କୁ ଆୱାର୍ଡ ହେଲା if you are not satisfied and you claim more, do you mean to say that there is no provision under the NH Act? Nine.
In the order itself, it has been spelled out. The prayer of the petitioner is rejected as amount payable as compensation and determined by this court under 3G15 ରେ ଯିବା ପାଇଁ arbitrator cum collector କୁହା ହେଇଛି। ନା ସେଠି କୁହା ହେଇଛି।
ସେ order ତ ମୁଁ କିଛି ଫାଇଲ କରିନି।
3G5 or 6 ର
Annexure 1 ଟା କାହାର? Where from we got this? Annexure 1 is
not rejected.
no. Who has filed this? It is not in your case.
Matter.
Then
Item 11 matter. Annexure 1. Item 11.
8019 ତ writ petition number?
ନାଇଁ
ହଁ
801.
801 ନା annexure 1 ଟା ପୁରା ଇଏ ଲେଖା ହେଇଛି।
Rejected.
ଏଣୁ ଆପଣଙ୍କୁ ନିର୍ଦ୍ଦେଶ ଦିଆଯାଉଛି
उपरोक्त आईन धारा 3E
हाँ
ର ଉପାଧାରା 1 ଅନୁଯାୟୀ ଆବଶ୍ୟକ ହେଉଥିବା ନିମ୍ନଲିଖିତ
नो
ଅନୁସୂଚିତ
नो ତାପରକୁ ଆସନ୍ତୁ
ନଚେତ ଆଇନ ଅନୁସାରେ
wait
order dated 4/1/23 ସେଇଥିରେ ଇଏ କରାହେଲା ପରା and this court is incapacitated to refer the matter to arbitrator cum collector. You should go.
ମାନେ ପାରା 2 4/1/23 ମାନେ page 12
order dated 4/1/2023 page number 12 ରେ ଲେଖା ହେଉଛି the prayer of the petitioner is rejected as the amount payable compensation is determined by the court under section so and so and this court is incapacitated to refer the matter to the arbitrator ଆପଣ ହିଁ ଯିବେ ତାକୁ ପ୍ରେୟାର କରିବେ ରେଫର କରିବା ପାଇଁ
we have approached under annexure
Annexure
2 matter
2
matter
representation nahi
thereafter the collector along with other officials as per under annexure 3 matter all officers taken decision to reconsider the grievance of the petition number annexure 3 page 16
annexure 3 is addressed to tahsildar
all the officers of the NH National Highway and assistant engineer NH subdivision also put his signature in that decision matter. Annexure 3 is the decision of the some officials.
PG5 clearly written on an application filed by the either of the parties, if the amount determined by the competent authority is not acceptable to either of the parties, the amount shall, on application by either of the parties, be determined by the arbitrator, right? So, to be appointed by the central government. You know, and this arbitration and conciliation act will be applicable. So, that ତାକୁ representation କଣ ଦଉଛନ୍ତି ଆପଣଙ୍କୁ ଦେଖିବାକୁ ପଡିବ ଯେ ଆମାଉଣ୍ଟ ଟା ଦିଆହେଇଛି ଏଇ ବେସିସ ରେ we are entitled to ସେ ତାର ଜମିର ମୂଲ୍ୟ ଏଇଆ ବା ପାଖରେ ଯୋଉ ଜମି ହେଇଛି ତାର valuation ଏଇଆ କରାଯାଇଛି ତେଣୁ ଏଇ ବେସିସ ରେ ଆମେ higher compensation we are entitled to get ତାକୁ ଦେଲେ ସିଏ it is to be referred and ultimately the arbitrator is to take a decision.
No, arbitrator. No, there is no need to examine. Provision is very clear. Arbitrator is the collector.
Just want to examine.
Arbitrator का collector, collector against order है district judge पाखे appeal करिए 34 रे.
Sir, next year भी तो इटा collector पाखे दिया है जात पर मैंने.
कोड दिया है जी. कहीं दिया है तो इठी पर क्या दिया है? Why did you come and read?
Next.
Where is your prayer that it is to be? All I do examine. The London Council for the petitioner 6 for an adjournment till next week to examine the relevant provisions of National Highways Act 1956, whether the petitioner has to file an application
the collector
before the collector with the arbitrator under section 3G5 for redressal of his grievance of claim of higher compensation. Matter will be listed next week. Go to date. Yes.
This is similar application probably we had yesterday.
Similar order.
We have fixed it to
summer.
after summer.
Number এটা কালির অর্ডারটা তো
কালি
এটা যাহা ଅଛି সেটা କରିଦିଅନ୍ତୁ যে
প্লট নম্বর খাতা নম্বর
ଖାଲି ପ୍ଲଟ ନମ୍ବର ଖାତା ନମ୍ବର ଚେଞ୍ଜ ହବ
କରିଦେଇଛି ପେନ୍ସିଲ
କରିଦେଇଛନ୍ତି ପେନସିଲ ଚେଞ୍ଜ କରି ରଖି ଯୋଉ ଡେଟ୍ ଅଛି ସେଇ ଡେଟ୍ କୁ ରଖିଦିଅନ୍ତୁ କୁଇକ୍ କରିଦେବେ ତା ସହିତ
Item 13.
हम प्रथम से जो ऑर्डर दिए थे 4/4/2025 I have filed the affidavit that after 2019 no repetition or any application is filed.
just
That is in paragraph 4.
स्ट्रक्चर आपण पाई जाइतले
आज्ञा
लैंड तार ओरिजिनल ये हेले इडको इडको कंपनसेशन अमाउंट रिसीव कर दैछन आपण को अल्टरनेटिव जमी दबा
आज्ञा
सो यू मेड एप्लीकेशन फॉर इडको
आज्ञा
इट हैज नॉट बीन गिवन
आज्ञा
यूजुअल कोर्स तांकर कोन व्हाट्स द प्रोविजन केबे देइतले
देई तो चलछि आ
देई चलछि माने कोन रिप्रेजेंटेशन देइजन केबे देइजन लास्ट रिप्रेजेंटेशन
19 रे
हैं
19 रे अब 1/2/2019
रिप्रेजेंटेशन अनेक्सर 10 त होची 19 रे हो
हां सीरीज करछि ना
सीरीज
24 हां 24/5/2024 पेज
काई
66
हम पकड़
पेज 66
66
आज्ञाମାନେ रिसीव करछन 28/5/2024
66 कोन कोन
सर 10 सीरीज तो
हम पकड़ सीरीज
मतलब लास्ट को अछि 57 को 66 फुट हैला
66 जाय मतलब फाइलिंग
देखि से बेटा फाइल था कि ना
এটা তো অনলাইন
ना देखु ना
आपण सेठी देखंतु आपण कागज कोन देइजन कोन नै देखु ना दिया रे
आपण एनेक्सर 10 सीरीज टा रिप्रेजेंटेशन 57 ରୁ 66 अछि किंतु हम पाखे 57 अछि
आपनकर सफाई ना तो
नै छपाई न आपण फाइल कर नथि कि छपाबो कोन थी आनी कोड छपई देबो ना
हां हां 66 पेज काई
नाही तो सेया को होची आपण को जे अछि बोली
मो फाइल तो आखि फाइल
आपण जेति की पठेइबे ऑनलाइन रे सेति की ही जे माने एठी पठेइबे ये करिवे तेणु आपण पाखरे जदी अछि एठी नाही तेणु
एठी ताको अधा काटी देबार किछि स्कोप नाही आपण जेति की देथिबे सेति की आड पास हो
इट मे बी दैट ता परठु आपण से जो ऑनलाइन रे फाइलिंग करचंती से 58 रु ये करनाती त सेटा फाइलिंग कर दियंतु सेटा
हार्ड कॉपी हेतला हम कहितांतु जे एति की आसला
ना फाइल अछि
हार्ड कॉपी अछि
हार्ड कॉपी फाइल अछि ना
ना ना फाइल करले ऑनलाइन रे हार्ड कॉपी फाइल करले केमते हो
ना ना हार्ड कॉपी भी एक्स्ट्रा फाइल अछि
हार्ड कॉपी नाही केवल ऑनलाइन रे फाइलिंग अछि यू डू वन थिंग 58 टू केते कहउचंदी 66 सेटा फाइल कर दियंतु देन सेटा को पुनी स्कैनिंग हेगिन पळाइसु आगे
एई तो कुछ असुविधा
the Learned and Counsel for the petitioner submits that he has filed the writ petition which consists of 66 pages. However, we find that the last page of the writ petition is page number 57. Therefore, the Learned Counsel for the petitioner shall file the remaining pages online, that is from page number 58 to 66. केबे फाइल करिवे बाय मंडे ट्यूसडे कर दियंतु देन by Tuesday
Monday file कर दो
अच्छा by Monday if the same is filed the matter will be listed on 22nd April 2025. Yes
फिर ये लक्ष्मी में एनपीआर का हार्ड कॉपी तो फाइल हिस्ट्री नहीं
आसिले जो मानकर आसुची हार्ड कॉपी पड़े आउची खाली जो माने ऑनलाइन सहित हार्ड कॉपी फाइल
तो मो पाखे नाही
yes next 22/4/2025. Yes
Item 14.
Fine. For addition to the opposite party to issue quota.
Issue
Quota number 330. Plot 3. So, Annexure 2 and Annexure 2, land, five papers of land has been settled in the name of father of the petitioner. While lease case number 1, 2, 2, 7 of
ନାଇଁ ରେକର୍ଡ ଅଫ ରାଇଟ୍ ପାଇଁ ଆପଣ
my lord.
ଇସ୍ୟୁ କରିବା ପାଇଁ ତହସିଲଦାରକୁ ଆପ୍ରୋଚ କଲେ ବାରଙ୍କୁ
I may be permitted to approve the Tahsildar for issuance of the leave be granted to that effect.
ଲିଭ୍ କଣ ଦବ ଆପଣ ଡକୁମେଣ୍ଟ ଦେବେ mutation ହବ ତାପରେ ଯାହା
ଆମର
ହବ
କଣ ଦରକାର?
I am
ଆମେ କଣ
permitted
କରିବୁ
to file application for
ଆରେ
issue.
ପରମିଶନ କଣ
free.
ଦରକାର ଆପଣଙ୍କ ଯଦି ଗୋଟେ ଜମି ଆପଣ କିଣିଛନ୍ତି
I should have filed before the Tahsildar.
ଆଉ ଏଠି କଣ ରିଟ୍ ରେ କଣ ପଳେଇ
Unfortunately,
It's the limitation with kitchen, any day you can
my
file.
mistake I have filed.
Yes.
the writ petition has been filed for such and such. The land council for the petitioner, after arguing sometimes, seeks permission to withdraw the writ petition to approach the Tahsildar Parang opposite party number 3 by filing appropriate application for issuance of ROR. Accordingly, the writ petition is disposed of. Yes, that's
Item 15.
This is the third round of litigation by the petition. Maybe yes.
Yes.
yes, 15 yeah.
This is the third round of litigation by the petitioner. In this case, petitioner is claiming promotion to category 2 in terms of amendment in the technical services rules of ICM. Basing on the similar order passed by the learned cat my lord. Certain cases have been filed in this particular case at court my lord. In this
ଆପଣ କଣ ଡାଇରେକ୍ଟ ପଳେଇ ଆଇଲେ ଏଠି
no man. Basing on my case, other cases have been disposed and they have come.
no you why have you not approached the central administrative tribunal?
I have approached my.
Where is the order?
And it is in
Annexure 1.
my lord.
Petition. Not our market. So what happened in the order?
Similarly placed persons have approached this.
Just a minute. The order in question is that the claim of the applicant, when examined in accordance with the rules applicable and factual circumstances of the case, and the pleading has no merit and OA was dismissed. So the OA was filed as it appears by you, Nattavaram Mahanti, with a prayer for a direction to the opposite parties to treat the applicant in P-2-3 grade with effect from 1/10/75, taking into consideration of the amendment which was made in 1979 and the order passed by this court in so and so. What do you say that similar matter?
Similar matter is pending before this honorable court, madam. And in that case, my case has been cited.
Just a minute. এটা তো কপি দিয়া ହେଇଥିଲା ତାଙ୍କୁ ଏକ୍ସାମିନ କରିବାକୁ ସିମିଲାର କେସ୍ କି ନାହିଁ ନଟବର ମହାନ୍ତି ଯୋଉ ଆପଣ similarly situated employee styled as Nottavara Mahanti versus so which was dismissed. The writ petition has been filed by the petitioner challenging the order dated by the center in dismissing the original property, taking into account that similar question came up for consideration before the tribunal in OA number so filed by the similarly situated employee styled as one which was dismissed on. When we put a pertinent question to the land council for the petitioner as to whether the order dated to 12 so so passed by the Central Administrative Tribunal in way number 213 of 2007 has been challenged before this court or not in common litigation. Land Council would seek some time to obtain necessary instruction in that related copy of this one to be served. List this matter along with one indicating. So, Colonel, say order.
Now they are challenging here in this writ petition.
Challenging. This will come back with.
After 6 years, they are challenging. 2019
Yes,
dismissed.
yes.
Now they are challenging.
This order was passed in 2019.
My lord, petitioner is 80 years.
Just
80 year. 80 year.
no, we are not on that. When you filed this writ petition,
My lord,
what is the date of filing of the writ petition?
February 2025.
9/4/2025
2 April.
ମାନେ second April to
ଏଇ 2 April
ଆଚ୍ଛା
25
ସେତେବେଳେ କେମିତି ଆପଣ 20/1/2025 ରେ
thereafter the petitioner suffered from COVID and thereafter he underwent complications related to COVID and had heart attack.
ନାଇଁ ମୁଁ ସେ କଥା କହୁନି ଆପଣ ଏଇ ଯୋଉ ଅର୍ଡରଟା ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ବୋଲି ଏଇ ଅର୍ଡରଟା ହଉଛି ପାସ୍ ହେଇଛି କେବେ 2013/2007 ଯୋଉଟା କି 2/12/2019 ରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି ରାଇଟ୍ ଯୋଉ ଅର୍ଡରଟାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ମ୍ୟାଟର ଯେତେବେଳେ 20/1/2025 ରେ ଟେକ୍ ଅଫ୍ ହେଲା ଆପଣ କେମିତି ସବମିଶନ କଲେ ଯେ ଅଲରେଡି ଇଟ୍ ଇଜ ଅଣ୍ଡର ଚ୍ୟାଲେଞ୍ଜ ବାଇ ଦି ବିଫୋର ଦିସ୍ କୋର୍ଟ ୱାଜ ଇଟ୍ ନଟ୍ ଏ ଇନକରେକ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ବୁଝିପାରିଲେନି
See, another council was appearing in that.
Another case council.
Not this.
ଏଇ ଅର୍ଡରଟା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ଏପ୍ରିଲ ମାସରେ ଏଇ ରିଟ୍ ପିଟିସନରେ ଆପଣ ଯେତେବେଳେ ହଁ ନାଇଁ ଏଇଠି ପରା କହୁଛନ୍ତି when it put
that man has taken the plea.
ଆଚ୍ଛା ଓ ସିଏ ଭୁଲରେ
ସିଏ
କହିଦେଇଛି
ଭୁଲ, ହଁ, ସିଏ ଭୁଲ।
ଆଚ୍ଛା not this man a wrong submission actually
Yes.
was made that OA number 213 of 2007 ro order dated 2/12/2019 has been already challenged
That is
in
not
the
correct.
High Court and it's a similar matter. ये सबमिशन ହେଇଥିଲା କେବେ ନା 20/1/2025 ରେ ସେତେବେଳକୁ ଚ୍ୟାଲେଞ୍ଜ ହେଇନଥିଲା ଚ୍ୟାଲେଞ୍ଜ ହେଲା ଏବେ ଏପ୍ରିଲ ସେ ହିଁ ଆପଣଙ୍କୁ କୁହାହଉଛି ବଟ୍ ୟୁ ଆର୍ ନଟ୍ ଦି କାଉନସିଲ ଇନ୍ ଦ୍ୟାଟ୍ କେସ୍
Let this matter be tactful.
ରିପୋର୍ଟରେ ଆସିଥାନ୍ତା ନାହିଁ ବୋଲି
ଇଏ ତାର ଚ୍ୟାଲେଞ୍ଜ କରିନି ସେ ତାର ଚୁପଚାପ ବସିଥିଲା ଇଏ ଯେତେବେଳେ ସବମିଶନ ଟା କରିଦେଲେ ତାକୁ ଯାଇକି ଆପ୍ରୋଚ କରୁଛନ୍ତି ଆରେ ତୁ କର ଆମେ ଗୋଟେ ଏମିତି ସବମିଶନ ଭୁଲଭାଲ କରିଦେଲୁଣି ଅସୁବିଧା ହବ ସିଏ କାହିଁ ଆସିଥାନ୍ତା 6 ବର୍ଷ ପରେ ଚ୍ୟାଲେଞ୍ଜ ଯେହେତୁ ଜାନୁଆରୀ ମାସରେ ଗୋଟେ ରଙ୍ଗ ସବମିଶନ
Immediately after the order, my lord, COVID ensued and
ନାଇଁ ସେତେବେଳେ ସିନା ଏବେ ଆମେ ଜାନୁଆରୀ 25 ର କଥା ଏପ୍ରିଲ 25 ର କଥା କୁହାହଉଛି ଜାନୁଆରୀ 25 ଯେତେବେଳେ ସେ ଏଇଠି ସବମିଶନ କଲେ ଯେ ନଟବର has already challenged this matter then it was not there ତାପରେ ଆପଣଙ୍କୁ କହିଲା ବେଳକୁ ଆପଣ ଆସିଛନ୍ତି ଏପ୍ରିଲରେ ସବମିଶନ ତ କରିଦେଲେ ଏଇଠି the matter is already before this court whereas it was not before this court Notabara was sleeping he got up only in April.
Actual fact is that he was suffering from COVID. Thereafter, he underwent COVID-related complications. Then had heart attack. Then actually, he did not have the.
Today he is comfortable.
Actually, police needed to look into this one.
So, counsel for the petitioner submit that similar matter is pending before this court in WPC number 13146 of 2025 and the matter may be tagged to the said case and he produced the copy of the order dated 21/2025 in WPC number 1346 of 2025. We find from the said order that a submission was made No, charge you. How?
But in this case, I am afraid for the email.
अच्छा, leave this matter along with charge. खाली कर देंगे ना. If you like to leave this matter along with the petition number.
I am for open note 2 to 4 for ICR, madam.
ଦେଇଦିଅନ୍ତୁ madam.
ଦିଅନ୍ତୁ ଆପଣ ଇଏ କରିଦେବେ.
I have instructed to attend nothing.
ନା ଲେଖିନି କୋଉ ଅପୋଜିଟ୍
ଆଜ୍ଞା।
ପାର୍ଟି ନମ୍ବର ଦେଇଦେବେ ଆମେ
Okay.
କରିଦେବୁ.
Okay.
Accordingly you file your wakalat number
Madam.
whatever you want. এটা opposite party number two ପାଇଁ এটা ଯୋଉମାନେ ଦେଇଛନ୍ତି ତାଙ୍କର ଭିତରେ note down କରିଦେବେ. Yes, next.
Item 16.
My limited prayer is to direct the appeal number 2 to dispose of the listed number 4 of 2023 pending before it since 2023. Well, my lord, what has happened? He has seen the petitioner file earlier another writ petition where the coordinate bench are directed to consider my representation within period of 2 weeks, 4 weeks. Thereafter, they have initiated the mistake number 4 of 23 that is pending since 8 months.
କଣ ଏଟା ମିଷ୍ଟେକ୍ସ ଟା କଣ ଯୋଉଟା ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 2 ରେ ପେଣ୍ଡିଂ ଅଛି କଣ ସେଟା?
To pay compensation for the on acquisition of the land for the construction of
ସେଇଟା
Khurda Balangir.
ରାସ୍ତା
No, it
ଆଉ?
Khurda Balangir landing project.
ଏଇଠି ଷ୍ଟୋନ ଷ୍ଟେକ୍ ହେଇନି ତ?
এটা 22/7/24 की डेट ମଧ୍ୟ ଅଛି
ଅଛି 22
ପେଜ 14
ମାନେ ମିସକେସ୍ ଟା
ମିଷ୍ଟେକ୍ସ ର ଡେଟ୍ ହେଇଥିଲା 22/7/24 କୁ ତାପରେ କଣ ହେଲା?
ତାପରେ मतलब ଖାଲି demarcation ପାଇଁ ଅଛି କିଛି କରୁନାହାନ୍ତି. Since 2023 matter is pending.
ଏ ମିଷ୍ଟେକ୍ସ ର ଅର୍ଡର ସିଟ୍ ଟା କାହିଁ?
Order sheet କାହିଁ?
ଆଉ
ଭାଇ
ପେଣ୍ଡିଂ ଅଛି ବୋଲି କେମିତି ଜାଣିବ? କଣ ହେଇଛି କଣ ନାହିଁ? ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ଡାଇରେକ୍ସନ ଦିଅନ୍ତୁ ଡିସ୍ପୋଜାଲ କରିଦବା ପାଇଁ ତାର କଣ ଷ୍ଟାଟସ ମନେକର ଆକୁ ଡିସ୍ପୋଜାଲ କରିବା ପାଇଁ କେତେ ଗୁଡାକ ଡକୁମେଣ୍ଟ ଦରକାର ହବ ବା କିଛି ଏନକ୍ୱାରି
ରିପୋର୍ଟ
ଦରକାର ହବ କଣ ରିପୋର୍ଟ ଦରକାର ହବ ତେଣୁ ବର୍ତ୍ତମାନ ଆମେ କରିଦବୁ 3 ମାସ ଭିତରେ ଡିସ୍ପୋଜାଲ କରିଦିଅ ତୁ ଅର୍ଡର ସିଟ୍ ଟା ଦେଖିଲେ ଜଣା ପଡିବ ଯେ କଣ ପାଇଁ ଏଇଟା ଆର୍ଜନ ହେଇକି ଚାଲିଛି ଯଦିଓ ଇନିସିଆଲ ଡେଟ୍ ଫିକ୍ସଅପ ହେଇଥିଲା 22/7/2024 for your appearance and you have already appeared. So you produce the order sheet of the miscase number. No? This writ petition has been filed by the petitioner Himanshu Bhushan Sahu with a prayer for a direction the opposite party number 2 collector cum district magistrate Nayagarh to dispose of miscase number 4 of 2023. However, we find from the notice issued to the petitioner, which is dated 18/7/2024, that the said miscase is fixed for hearing to 22/7/2024. The Land Council for the petitioner submits that the petitioner has already entered appearance after receipt of the notice, but the matter is getting delayed and therefore necessary direction be issued. The Land Council for the petitioner has not filed the order sheet of the aforesaid miscase number 4 of 2023. He seeks some time to do the certified copy of the order sheet put of this matter. Keber of your phone?
3 weeks. 3 weeks.
3 weeks time, summer vacation for
Already union representation opposite party number.
Yes,
number.
They'll just come.
Item 17.
The petitioner is seeking the direction for the opposite party to extend the admitted benefits under the right to compensation, parent compensation, transparency, and in land acquisition and Rehabilitation and Resettlement Act. Plus, if my annexure, my representation under annexure 3 is pending before opposite party number 2. Plus, if my house, I have evicted from the my house since 2023, but till date no compensation has been given.
Earlier you have,
Yes, Lordship, I have filed
and that was
WPC.
that was considered.
That has considered, but the Lordship, I have only preferred the structure value and the fruit bearing compensation amount.
No. What was the order then? As agreed by the land council for the parties, this court, without expressing opinion, disposes the writ petition directing the opposite party number 3 to take decision on the representation filed by the under annexure 3.
What decision was taken?
Lordship, only they have a speaking order to compensate me. They have assured me, but
Madam, where is that order?
Below
Lordship,
that.
page 17.
Below that.
Outside.
Below that.
Okay. Oh, that is not speaking order.
Yes, sir.
So,
Again, representation then. The encroached land, you have been evicted.
so your representation has been considered and it has been rejected. So again, why you are filing the representation?
Lordship, I have only prayed for the structure value and structure.
You make application before the authority.
Lordship, I have given several representations, but
Representation पर आपनकर
ହେଲା ତ
ଆପଣ
consider
ଦେଲେ ଆସିଲେ ହାଇକୋର୍ଟ କୁ ହାଇକୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଲେ ଏବଂ ସେଟା କନସିଡର ହେଇକିନି reject. Now you have to show that if there is any illegality in the rejection order of your representation, that can be पुणी ଆଉ ଗୋଟେ representation file କରି पुणी ଆଉ ଥରେ direction ନବାକୁ କଣ ପାଇଁ ଇଏ କରୁଛନ୍ତି ଆପଣଙ୍କର ତ order already ହେଲା ଏବଂ ସେମାନେ reason ଦେଇକିନି dispose of କରିଛନ୍ତି ଯେ you are not entitled to get that ତେଣୁ ଆପଣଙ୍କର representation ଟାକୁ dispose of କରିଦେଲେ in that line. The petitioner had encroached the railway land and has been residing there unauthorizedly, directed to vacate the wrongful and illegal occupation of plot number so and so near the second entry of railway station Tislagarh on or before 15 days of receiving this letter. So again, apuni goda representation kon.
I have petitioner is states they are more than 50 years.
No, then you have to challenge the illegality of this order. No? What is the purpose of another representation?
Lordship, I have only prayed for the claim of the structure, compensation of the structure, the house that was demolished and the fruit bearing trees that has been.
That has already been demolished.
Yes,
you have already been evicted.
I have already evicted from.
How that survey will be done? Who will do it?
No question of again directing it. We do not know what is the structure they are, whether the fruit bearing trees were there or not. And you have enjoyed that property of the railways unauthorizedly for so many years, 50 years, as you said. And legally constructed, and it is they are not acquiring their land for which for even for unauthorized structure you are entitled to get something. But
they have evicted you.
They are evicted. The writ petition has been filed by the petitioners, so and so, for a direction to the opposite party to dispose of the representation under Annexure 3 and to extend the benefits of so and so 2013 Act and RR policy to the petition. It is not a case of land acquisition. the petitioner seems to have encroached the railway land and residing there unauthorizedly. And earlier he submitted a representation before the authority, and since the same was not considered, he approached this court in WPC number 35998 of 2022. And this court, by order dated 23/12/2022, disposed of the representation, directing the opposite party number 3 to take a decision on the representation filed by the petitioner. Accordingly, the representation of the petitioner was considered, and a speaking order dated 9/2/2023 was passed, wherein it is clearly mentioned that the petitioner has encroached the railway land and has been residing there unauthorizedly, and therefore he was asked to vacate the wrongful and illegal occupation of plot number 1242, H number 473 of Titlagarh KHA, near second entry of railway station Titlagarh, Siravata Pada Chowk, Titlagarh, district of Balangir. Line counsel for the petitioner submits that in the meantime, the structure has been demolished, and the fruit-bearing trees have been cut and removed, but the petitioner has not been paid any compensation amount. There is no documentary proof or to that effect, and since the first representation was directed to be disposed of, and accordingly the same has been disposed of, and reason has been assigned therein for directing the petitioner to vacate the wrongful and illegal occupation. Another representation has been filed by Annexure P, and seeking for a direction to dispose of the representation is not maintainable. Accordingly, the writ petition being devoid of merit stands dismissed. Yes, next.
Sir, I am appearing for Union of India.
To also appears for the Union of India. Yes, next.
Item 18.
Also, item 18, pray for next week.
Item 8. Next week, Learning Council. Yes.
Item 19.
19. You can challenge the order passed by the honorable staff in OA case. It seems like the order has been passed in a batch of OAs. Some of the petition, in some cases, state has challenged it, and that has got dismissed. Well, verify whether any appeal has been filed in the meanwhile.
The writ petition has been filed by the state challenging the order dated 11/4/2012 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack. State Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 1341C of 2010. The Land Council for the state submits that a batch of original applications were disposed of in a common order, and in some cases the state has challenged the state order, and the writ petitions have been dismissed. However, some time may be granted to verify whether any writ appeal has been filed challenging the dismissal order passed in the writ petition.
Much.
Put up this matter. Keble kuhantu
7 days. Your Lordship.
7 days. Put up this matter in the convention from 12th May 12th May 2020.
Item 20.
Order of the Central Administrative Tribunal on the challenge the application. That is order passed on OA number 687 of 2019 under Annexure 1 in actually kindly at page 70.
What is the prayer made in the original application by that Narahari Mukti?
Madam, that
What is the relief sought for?
approximately kindly at page 20.
20 money.
Internal
Of the annexure 1.
Yes, madam. Internal page of 4 of the running tribunal's order, madam.
Page 20, okay.
Yes.
Internal page 4.
Para 4, madam.
Para 4.
Being aggrieved by may I read it, madam? Being aggrieved by the aforesaid communication, the applicant has referred this way along with MA 937
For condemnation of delay.
for condemnation of delay. The prayer in the OAR is under the pass appropriate orders passing the impugned order dated 13/7/2018.
Consider
That rejecting this order that has been quoted in above manner. That your Lordship may kindly say that this representation has been rejected by the petitioner for consideration of his case for trade test.
Okay.
And that is the circular 17 for annexation by 1 to pass appropriate orders directing the respondent to consider the case of the applicant for the promotion to the post of merit by condoning necessary trade test like other similar situated persons as per the SR number 169 of 2004, and further extended all of the subject benefit consulants benefit in his favor to which he is eligible to entitle to pass appropriate order. But the case of the petition is that matter. So far as the tribunal has been by observing that the delay in filing of the original application that has been condoned, and you Lordship may kindly see the contention of appellant opposite party of the defense at para 9 you Lordship may kindly see.
Good trade test koriyo କହିଛନ୍ତି.
Well,
within the period of 30 days.
The difficulty is that in the meantime, the header cadre, the petitioner of the Chowkidar and the Safai Wala, with the class 4 employees of the defense department. The earlier the SUR which has been governed, which is the feeder cadre to the promotion to the post of merit, that has been superseded by the new rule in 2013. That previous rules is governed till 7/7/2013, and subsequently when this notification of SUR come in force in 2014, 13 itself, the field there and the direct recruitment for the feeder cadre.
No, ଆପଣଙ୍କର main contention like you come to paragraph 9 of the impugned order. Internal page which is 7. Please place it. In view of the
above, proceeding to decide the grievance of the applicant on merit, we find that the whole case of the respondent is that since the applicant did not offer his willingness for trade test, and thus he having not fulfilled the required condition up to 7/7/2013. This is that the rule he has been superseded. His case was rightly not considered for promotion as per the rules, but the respondent did not produce any piece of paper to show that such willingness had ever been called out. The applicant did not offer his willingness. No rule is also brought to the notice that the official on their own had to seek to appear in the trade test. The trade test is supposed to be conducted by the respondent department for its eligible employees. Therefore, non-submission of the willingness of the applicant to appear at the trade test, the respondent can only be blamed. In these circumstances, the stand taken by the respondent that the applicant did not offer his willingness to appear in the trade test at Chandipur, when such trade test was never conducted during the period in question, as per the report, cannot be against the applicant. The order of rejection is also continuously silence on the above, except that the respondent has simply stated that the applicant did not offer his willingness for the trade test. For the reason stated above, this tribunal is constrained to hold that the applicant
କଣଟା
is
ହେଇଛି ଆପଣ
reconsidered.
କହୁଛନ୍ତି ସିଏ ୱିଲିଂନେସ୍ ଦେଲାନି
Manner.
ଆପଣ ସିନା ତାକୁ ଗୋଟେ ଡକୁମେଣ୍ଟ ଦେଇଥିଲେ ଯେ ଆମେ ଏଇ ଟାଇପ ର ଇଏ ପାଇଁ ଆପଣ ୱିଲିଂନେସ୍ ଦିଅନ୍ତୁ ସେ ମନା କରିଥାନ୍ତା ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ ଆପଣ ତ ତାକୁ ଜଣେ କିଛି ଡକୁମେଣ୍ଟ ହିଁ ପ୍ରଡ୍ୟୁସ କରିପାରିଲେନି so that is how the Learned Tribunal has been pleased to hold that no rule has been brought to the notice that an official on their own has to seek to appear the trade test because you are to conduct the trade test and you are to ask them whether you are ready and willing to undergo the trade test or not.
Admittedly, man, the fact remains, all these feeder cadre, they will be promoted to male as per the SUR which has been in force till 7/7/2013. What happened when the new circular has gone? This mate is the semi-skilled persons who have been selected for the defense, the research organization for all the establishment of the defense organization. That therefore, taking in account that semi-skilled persons is needed at the recruitment process, this amendment has come in force and the recruitment rule has been amended. Thereafter, the feeder cadre which has been promoted from the Sapaiwala and the Chowkidars, that has been seized in 7/7/2013. During that period, admittedly, my lords, in Odisha, Chandipur, there is no conducting of the during that period as reflected in the order. But that has been conducted in the Calcutta, Calcutta office. When this all the grievances has been raised before the Ministry of Defence regarding clarification necessary for the whether all will be considered or not, they had qualified and this is a part of the record. I have annexed A by 1 of the OA. OA also I have annexed 2. You'll also make kindly see page 40. 40 running page 5. That is the letter of the head office New Delhi regarding clarification so far as may I read it, my lord?
ये जो प्रथम सेंटेंस टा जो पैराग्राफ नंबर 2 रे जोटा लिखा है इम्प्रूव्ड ऑर्डर रे
yes sir.
In terms of SRO number 169 dated 9/11/2004 please come to the order impugned order paragraph number 2.
Yes sir. No. Yes sir.
In terms of SRO number so and so, the Mazdoor and Chowkidar and Safai Walas are eligible to be promoted to the post of mate subject to residency period of 4 years of regular service in the feeder grade and passing of the trade test to be conducted. এই जो अन्य ये गुड़ाक तार से क्वालिफिकेशन गुड़ाक अच्छी.
Yes ma'am.
Only thing is that he has not passed the trade test.
Yes ma'am.
Now you are taking a ground that since he has not passed the trade test, he cannot be promoted to the post of mate.
Ground, madam, I beg your pardon. Because we have stated that in view of new rules came into force on 8/7/2013 onwards, the grievance of petitioner cannot be taken in account. He has not.
What is the new rule?
That is, your lordship, that has been that is clarified. Your lordship, can say as per 40.
No. Where is that new rule?
Yes, man. I had not annexed.
No, that means not your plea before the OA. That was not your plea in the OA.
No, man. That is the case, man.
So
that is the case.
ସେମାନେ ଯେତେବେଳେ ଏଣ୍ଟାଇଟଲମେଣ୍ଟ ଥିଲେ ସେତେବେଳକୁ ଆପଣ ଟ୍ରେଡ ଟେଷ୍ଟ କଲେ ନାହିଁ ତାପରେ 2013 ଗୋଟେ ରୁଲ ନେଇ ଆସିଲେ ତ ଯଦି ଆପଣ ଏଇ ରୁଲ ଯେତେବେଳେ ନଥିଲା ସେତେବେଳେ ଯଦି ଟ୍ରେଡ ଟେଷ୍ଟ କରିଥାନ୍ତେ ତାହେଲେ ସେ ଆପିୟର କରିଥାନ୍ତେ ଏବଂ ଯଦି ତାକୁ କ୍ୱାଲିଫାଇ କରିଥାନ୍ତେ they would have got the post of that mate
My lord.
right?
That is
So
that,
if you did not
Conduct it, yes.
conducted that trade test, subsequently bring another
Another rule.
rule.
that it is a, just like a promotional post, my lord. It is subject to availability of the vacancy. All that has been conducted and will be promoted.
You said that in Calcutta it was conducted.
Yes,
Just
my
now
lord.
said
That
it
is
was
the
conducted.
reason I want to place your
That is not your case, that no such post of mate was there available then. Your case is that he has not passed the trade test, and admittedly that trade test was not conducted by, and you are responsible for that.
Well, that what I bring to Hon'Ble submission before the lordships. That has when that should be prior to 3/7/2013, not thereafter. That
No. Yes.
2013 ପୂର୍ବରୁ ମନେ କରନ୍ତୁ ତାଙ୍କର 4 ବର୍ଷ ରେଗୁଲାର ସର୍ଭିସ ହେଇନଥାନ୍ତା, ଆପଣ ଗ୍ରାଉଣ୍ଡ ନେଇ ପାରିଥାନ୍ତେ। ଆଜ୍ଞା 2013 ପୂର୍ବରୁ ତାଙ୍କୁ ଜଷ୍ଟିଫିକେସନ ନାହିଁ ତାଙ୍କୁ କନସିଡର କରିବାକୁ।
Residency period was not completed.
That is also subject to availability of the vacancy, madam. Not that.
No, that is not your ground, sir.
ଗ୍ରାଉଣ୍ଡ ହିଁ ନାହିଁ ସେଟା। ଆପଣ
there was no availability of
କାଉଣ୍ଟର ଆଫିଡେଭିଟ ବି ସେ ଲାଇଟ ରେ ନାହିଁ। ଆପଣ ପ୍ରଥମ କରି ପାଇଁ ଏଠି ରିଟ୍ ପିଟିସନ
vacancy ନାହିଁ ବୋଲି ଆପଣ ଅଛି ଗ୍ରାଉଣ୍ଡ ଗୋଟେ ବି?
ଇଜ देयर एनी ग्राउंड ଯେ ମେଟ୍ ର କୌଣସି ପୋଷ୍ଟ ସେତେବେଳେ ଭ୍ୟାକାନ୍ସି ନଥିଲା?
You also may kindly see page 54 my counter affidavit. I have annexed the OA and counter itself. Page 54. Annex 3 the my counter.
Page 54. Code election
54 para 70. That is declared to appropriate made in para 5.4 to the original application. It is humbly submitted that the trade test in terms of SOR 169 of 2004 is to be conducted on the basis of availability of vacancy and availability of willingness option from the eligible candidate.
No, that is a vague fact. ସେତେବେଳେ କୌଣସି ଭ୍ୟାକାନ୍ସି ନଥିଲା। ଏଇ ଭଳିଆ ଗୋଟେ ଲାଇନ 2013 ରେ ଯେତେବେଳେ ଆପଣ ରୁଲ ଆଣିଲେ,
truly it is subject to availability and passing of the trade test. That is there. But there is no availability of vacancy.
ଆଉ ଯଦି ଗୋଟେ ଲାଇନ ମନେକର ଏଠି ଆଡ୍ କରିଥାନ୍ତେ, that till the rule was brought in 2013, there was no vacancy in the post of mate.
You also that has been clarification has been made under Annex 1 that has been annexed.
Only ground is trade test which you did not conduct.
Because that in view of
then you change the rule and you are
that has been subsequently.
All right, this writ petition has been filed.
Just I subject to lordship's concern and the trial court also, the tribunal also held that he should give all the benefit from the counterpart.
Trade test କରିବେ, trade test ମନେକର ସେ ମାନେ ପାସ୍ କରିବନି ତ ପ୍ରଶ୍ନ ଉଠୁନି ନା।
That has been already you lordship
ଅର୍ଡରରେ ଅପରେଟିଭ ପୋର୍ସନ ଦେଖନ୍ତୁ, ଆପଣଙ୍କୁ କୁହାଯାଇଛି ଡାଇରେକ୍ସନ ଦିଆଯାଇଛି କଣ କରିବା ପାଇଁ, ଯେ 30 ଦିନ ଭିତରେ ଟ୍ରେଡ ଟେଷ୍ଟ ଆଉ ତାପରେ ରେଜଲ୍ଟ ର ଟ୍ରେଡ ଟେଷ୍ଟ ଉପରେ ବେସ୍ କରିବ ସବୁ ଜିନିଷ। ତେଣୁ ଯଦି ଟ୍ରେଡ ଟେଷ୍ଟ ମନେକର ସେ କ୍ୱାଲିଫାଇ ନ କଲା, ତାହେଲେ ଯୋଉ ପ୍ରମୋସନ ବା ଅନ୍ୟାନ୍ୟ ଦବାକୁ ପ୍ରଶ୍ନ ଉଠୁନି ନା।
If to be qualified, then all what that he should be give the promotion benefits subsequently, not the rest of it.
ସେ ଆଗେ ପ୍ରଥମ ହର୍ଡଲ ଟା ପାସ୍ କରୁ, ଆପଣ ତ ମୂଳରୁ କରିବା ପାଇଁ tribunal direction ଦେଇଛନ୍ତି ତା against ରେ ପଳେଇ ଆସିଛନ୍ତି।
That is you also may kindly see 1, 2, 3 tribunal has been specified.
We are reading once again. The respondents are to hold the trade test for the applicant within a period of 30 days from the receipt of the order. Based on the result of the trade test, the case of the applicant is to be considered. So question is that trade test ମନେ କରନ୍ତୁ ସିଏ ପାସ୍ ନ କଲା, ତାହେଲେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆସିବ କୋଉଠି? ଯଦି ପାସ୍ କଲା ଦେନ୍ ଆସିବ।
Then my second line of submission is that he should be not get the benefit in the date of the promotion.
ଯାହା benefit in available under law ଥିବ ତାକୁ ଦେବେ।
That has clarified because the tribunal has specifically like the mere thing to effect from the date his counterpart employees are promoted.
ନାଇଁ ସେ କଣ କହିଛନ୍ତି, ଟେଷ୍ଟ ରେଜଲ୍ଟ ହେଲା ପରେ ତାପରେ କଣ ଲେଖିଛନ୍ତି? Just a minute. The applicant will have to be considered by the respondent by convening DPC, review DPC to consider his case for promotion to the post of mate with effect from the date of so and so এই জিনিসটা তারপরে করিবে
that will follow because it is the specific direction 1 2 3 once you leave
ଏଇଟା ପରା ଆପଣଙ୍କର ଅଛି ଯିଏ ଟ୍ରେଡ୍ ଟେଷ୍ଟ ପାସ୍ କରିବ ତାକୁ ଏଇ ପ୍ରୋସେସ ଦେଇକି ଯିବାକୁ ପଡିବ ନା ସିଧା ତାକୁ ସେ ପୁଣି ଡିପିସି ଡକାଯିବ ଡିପିସି ଡକା ହେଇଲେ ତାର କେସ୍ କନସିଡର କରିବ ଏବଂ ତ
only my
କୋଉଠି ଲେଖା ହେଲା କୋଉଠି where is that order you are saying
a page number internal page
the promotion
internal page रे
with the effect from the date his counter
number
will be
କରାଗଲା
then because this laches whatever is shown is attributed to you why not on the date why he will lose why he will lose
you have to convene a DPC otherwise how his case will be considered
he must be at par with his counterparts it is correct why he will lose he will lose because of your inaction
that because that subsequently that
no
new rule
had this trade test been conducted then he would have been promoted from that day and if you would have shown that there was no availability of vacancy then probably he would have waited that is also not your case so neither way you are justifying
taken in the
no
only mention that and the I understood A by 1 that has clarified
in any case if he succeeds in trade test then he has to be at par with his counterpart you cannot stop
the petitioners filed this writ petition challenging the order dated 29/8/2024 passing OA number 687 of 2019 by the Land and Central Administrative Tribunal, Cuttack Bench Cuttack. The opposite party opposite parties filed the OA number 260/00687 of 2019, wherein prayer was made as follows. Quote paragraph number 4 with our prayer. It is the case of the petitioner, opposite party, that in terms of SRO number 169 dated 9/11/2004, the Mazdurs and Chowkidars / Safaiwalas were eligible to be promoted to the post of mate, subject to a residency period of 4 years regular service in the feeder grade and passing of the trade test to be conducted by the deponent. Department. The said rule was invoked till 7/7/2013 and thereafter the promotion of Mazdoor and Chowkidar / Safaiwala to mate was ceased to be in operation with effect from 8/7/2013 by virtue of introduction of SRO number 48 dated 8/7/2013. It is the case of the opposite party that no trade test was ever conducted by R&D Chandipur, Baleswar, Odisha, though such test was conducted in the eastern region at Kolkata at a regular interval, and thereby the juniors of the opposite party were promoted to mate, whereas the opposite party was discriminated against. After issuance of notice, the petitioners entered appearance and filed their counter affidavit, wherein the main ground that has been taken that trade test in terms of SRO number 169 of 2004 is to be conducted on the basis of availability of vacancy and availability of willingness option from the eligible candidates. The opposite party had never submitted his eligibility as well as willingness option for the specific trade within 7/7/2013. The London Tribunal, after hearing the respective parties, has been pleased to hold as follows. Quote from paragraph number 9, entire paragraph number 9. The London Council for the petitioner submitted that since there was no vacancy in the post of mate and the petitioner has not passed the trade test, therefore the question of his promotion to the post of mate does not arise. However, from the counter affidavit, we find that there is no such averment that till the introduction of SRO number 48 dated 8/7/2013, there was no vacancy in the post of mate. So far as conducting of trade test is concerned, the London Tribunal is quite justified in holding that there is no document produced to show that any such willingness had ever been called for from the opposite party, and he did not offer his willingness. And the petitioners are to conduct the trade test for promotion, and if they did not conduct the said test, the opposite party cannot be allowed to suffer prejudice or to be blamed. Therefore, we are of the view that there is no infirmity or illegality in the order passed by the Land Central Administrative Tribunals. The reasons assigned therein are quite justified. Accordingly, the writ petition being devoid of merit stands dismissed.
I don't mention hearing number 352 of 2011 that the appellants have been convicted under section 302 of IPC and has been custody since 27/8/2007. Member.
Hmm.
Give it.
Yes.
For more than 9 years.
I may be pardon.
Yes.
Yes, I know 24 paper book nahi. Hearing पे increase.
Take 4 years.
ଆଉ ସେ ଆଗ ପଛ ସମସ୍ତଙ୍କର ପେପର ବୁକ୍ ଅଛି ଖାଲି 24 ଟା ନାହିଁ.
Yes. Done.
Supplemental list, item number 1.
Deposition copies are supplied.
Wait.
My lord, if Mr. Sudhanta Tripathi is engaged in this case, we have no eviction.
ରାଷ୍ଟ୍ରୀୟ ଗୋଟେ ଯୋଜନା petition 12/3/24 ବୁଧବାର
This prisoner petitioner will flag you.
ଆପଣ କାହା ପାଇଁ
Mr. Gokulananda sir.
ଆପଣଙ୍କୁ ତ ଦେଇଛି ଏନଗେଜ କରିବା ପାଇଁ କଣ ଅସୁବିଧା ହଉଛି ଲାଷ୍ଟ ଲେଟର ଟା 12/3/2024 ସେ ଲେଖୁଛି ଯେ ମୁଁ ବର୍ତ୍ତମାନ ମୋ କେସ ର ସୁପରିଚାଳନା ପାଇଁ ଓକିଲ ଶ୍ରୀ ଗୋକୁଳାନନ୍ଦ ସାହୁଙ୍କୁ ନିୟୋଜିତ କରିବା ପାଇଁ ଚାହୁଁଅଛି ତ କଣ କଣ କହୁଛନ୍ତି
ତା ସହିତ ସେ ସୁଧାନ୍ତ ତ୍ରିପାଠୀକୁ ଏନଗେଜ କରିଛନ୍ତି
ଓକାଲତନାମା ଫାଇଲ କରିଛନ୍ତି ପରା
ନା ଆମେ ଫାଇଲ କରିନୁ
କରୁନାହାନ୍ତି ତ ଏଠି ବ୍ଲାଙ୍କ ଅଛି ସେ ପଠେଇଛନ୍ତି ଓକାଲତନାମାଟାକୁ ଫିଲ୍ଅପ୍ କରିଦେବେ ଫିଲ୍ଅପ୍ କରି ଫାଇଲ କରିବେ ସେ ତ ଅଲରେଡି ପ୍ରିଜନର୍ସ ପିଟିସନରେ ଲେଖିଛନ୍ତି ଅସୁବିଧା କଣ ହଉଛି ଆପଣଙ୍କୁ କଣ ଅସୁବିଧା ହଉଛି କଣ ଚାହୁଁଛନ୍ତି କହୁନାହାନ୍ତି
ଓକାଲତନାମା ଫାଇଲ କରିଦେବୁ
ଓକାଲତନାମା ଆମେ ଦବୁ ଆପଣଙ୍କୁ ଭେରି ଗୋକୁଳାନନ୍ଦ ସାହୁ
ସି ଇଜ another court
call him ହେଲା ଆସିକି ଫିଲ୍ଅପ୍ କରିଦିଅନ୍ତୁ ହେଲା
Hello.
we'll engage him we are passing it over
Item 2.
The criminal appeal. He is 81 years old. The legal service operator provided the report of the NASA special campaign.
କାହିଁ ଇଏ କାହିଁ ଏ ଯୋଉ ଫର୍ମାଟ ଟା କୁଆଡେ
health and
Office provide.
Copy.
ଏଇ ଫର୍ମ ଟା ଯେ ଠିକ ଅଛି
ଦେଇଦେଇଛି
ଏଟା ତ ଡାଇରେକ୍ଟ କୋର୍ଟରେ ପଠେଇବା କଥା ଆପଣ ଏଠି କେମିତି ଦେଇଦେଲେ ଆପଣ ହାତରେ
Legal services authority has given.
କଣ ହେଇଛି
Legal services authority.
but it's come to the
from the secretary ଆଚ୍ଛା ଓ ସେମାନଙ୍କ ପାଖକୁ ଆସୁଛି
ଆଜ୍ଞା
ସେମାନେ ଆପଣଙ୍କୁ ଇଣ୍ଟରେଷ୍ଟ କରୁଛନ୍ତି ଅଫିସିଆଲ ଲେଟର ଅଛି ଠିକ ଅଛି have you given a copy to madam
ସେଇଟା ହେଲେ ମାନେ କପି କରିକି ଗୋଟେ ଦେଇଥିଲେ
यार ଗୋଟେ କପି କରିକି ଦେଇଦିଅ ନାଇଁ ସେ ଦେଇଦେବେ କପି କରିଦେଇଦେବେ ଆଉ so you obtain instruction on this the land council IN number so and so this is an application for bail the land council for the petitioner has produced the format A format A for you the form meant for NALSA campaign on old prisoners and terminally ill prisoners, wherein it is mentioned that the petitioner is aged about 81 years.
କେତେ ଲିଙ୍କ୍ ଅଛି ସେଟା ଯୋଉଠି ରଖିଲେ ତା ସୁବିଧା ନାହିଁ ଖାଲି ଫର୍ମ ଟେ ଦେଇକି ରିପ୍ଲାଏ କରିଛି
ये जो ये नालसा जो स्पेशल कैंपेन का गाइडलाइन था
This is also
Copy रे रखिए Have you gone through this?
Yes.
So you see, in older prisoners, there is a requirement that release on compassionate ground older prisoners who are in need of constant. Are you getting that?
Yes.
You come to page number 2. Second page को पढ़ा सुन.
Last page.
1.4
No.
survey.
1.4 रो गोटा अछि A रे older prisoners अछि.
Yes.
Older prisoners तास next ये को पढ़ा सुन.
Yes.
जोटी hyphen दिया है.
Release on compassionate.
Please read it out.
Release on compassionate ground older prisoners who are in need of constant specialist nursing care and who do not pose a risk to the society, transferring them to an appropriate institution in the community. Encourage and facilitate contacts between the older prisoners, legal aid services of the appropriate state in order to assist such prisoners in gaining early conditional and compassionate relief.
तो से application ହେଲା परे आपण जदि भी एज ग्राउंड रे apply होउची ताले you are to obtain a
Instruction whether they're in need of any
certificate to
special.
that effect.
Yes.
जे एमानेଙ୍କର केवल बयस तो 70 प्लस ହେଇନି बट ସେମାନେ
need
ଏଇ
this.
कंडीशन को satisfy କରୁଛନ୍ତି.
Yes.
बुझिले?
Yes.
ତେଣୁ you are to take instruction on that, huh?
Yes.
Mentioned that the petition yes. The copy of the application form is served on the land council for the state who seeks some time to obtain instruction from the jail superintendent. The terms of the guidelines enumerated in the special campaign for old prisoners and terminally ill prisoners issued by National Legal Authority. Put up this matter in the week commencing from at a co-jail ଅଛି ସେ Tarchier. So 29 asu upon lay asu
29.
29
29.
or you want
29.
29th of April 2025 आर ଗୋଟେ କପି ରଖିବ ଏ ଫର୍ମ ର ଯୋଉ fill up କରିକି ଦେଇଛି ତାକୁ
ଦେବଗଡ଼ ଜେଟ୍ ଅଛି
Devagad रे.
second instruction
Riyamal ର ବୋଲି କି.
ଆଜ୍ଞା।
ହଁ, Devagad.
one copy I will take.
ହଁ ସ୍ପିକ୍ କରିକି ନା ଆପଣଙ୍କୁ ଦେଇଦେବ.
Item 3.
Item 3, file bail application in view of special campaign of Nalsan.
ଦିଅନ୍ତୁ
Old age.
ଫର୍ମ ଆସିନି ତ ଆପଣଙ୍କୁ ଦେଇଥାନ୍ତି ତ ଦିଅନ୍ତୁ. ଏଜ ଗ୍ରାଉଣ୍ଡ ରେ ନା ଟର୍ମିନାଲ ଇଲନେସ
Old age.
ଓଲ୍ଡ ଏଜ କେତେ ବର୍ଷ ଲେଖା ହେଇଛି
70.
କପିଟି ଦିଅନ୍ତୁ ତାଙ୍କୁ ଇଏ କରି ଦେଇଦିଅନ୍ତୁ ଜେରକ୍ସ କରି ଦେଇଦିଅନ୍ତୁ ଆଉ ସେମ୍ ଅର୍ଡର କରିଦେବେ. କୋଉ ଜେଲରେ ଅଛି
Culture.
Tarchier.
Culture sub.
ସେମ୍ ଡେଟ୍ 29
20.
ଏଇଟା ହଉଛି ନମ୍ବର ଦିସ୍ ଇଜ ଆଇଟମ ନମ୍ବର 3 ରେ IN ନମ୍ବର ସୋ ଫର ବେଲ୍ ଲେଖିବେ ହେଲା ତାପରେ ସେଠି ଯେମିତି ଲେଖା ହେଇଛି ସେଟା ଲେଖିବେ. Yes, next.
Item 4.
Prisoner's application, my appearance may be
Later of the High Court is on that flag in petition number so. Report. Next petition at flag K. କଣ ଆପଣ ଚାହୁଁଛନ୍ତି
ମୋ appearance ଟା ignore କରିବେ
କାହିଁକି
ମୁଁ ଗୋଟେ ଷ୍ଟେଟ୍ ପ୍ୟାନେଲ ଅଛି
ଷ୍ଟେଟ୍ ପ୍ୟାନେଲ ଅଛି
ଆଜ୍ଞା ଆଉ ସେଟା
ନାଇଁ ନାଇଁ ଠିକ ଅଛି ହଁ somebody else is to be Sanam Pachari, Mr. Devendra Kumar Sahu, Land Council submits that since he is now in state panel, his name may be deleted. So and so is engaged as a amicus curiae. The petition has been filed by the appellant under so and so in form number form for NALSA special campaign and so on, so wherein the age has been mentioned to be 71 years. Copy of the application form has been served on the Land Council for the state. Will take instruction in the matter of this matter. See, out of secret on 29th of April 2025.
Item 5.
One week. Input record is record. Judgment question. Case of problem. Have you got the deposition copies?
yes sir
All right. IA number 298 of 24. There is an application for bail. Land Council for the appellant 6 adjournment for 2 weeks. Put of this matter after summer vacation. Ensuing summer vacation. Yes. Next.
Item 6.
on behalf of CHITTARANJAN, I may be present.
Highly criminal for death of the elder brother. What instruction of the district? ಈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅನ್ಸಂಗಿ ଆପଣ କୁହାଲା ସିଏ ତାଙ୍କ ଶୁଦ୍ଧିକ୍ରିୟା ପାଇଁ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି ତା ଦେହରେ ଗୋଟେ ସରପଞ୍ଚର ଗୋଟେ ଡକୁମେଣ୍ଟ ଆନେକ୍ସ କରୁଛନ୍ତି ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବାକୁ କାଲି କୁହାହେଇଥିଲା ଯେ ପ୍ରକୃତରେ ତା ବଡ ଭାଇ ମରିଛି କି ନାହିଁ ଆଉ ଏଇଟା କଣ ଲେଖିଛନ୍ତି ତା ବାପା ରହୁଛି 4 ପୁଅ ଇଏ କଷ୍ଟୋଡିରେ ଅଛି କଷ୍ଟୋଡିରେ ନାହିଁ ଆଉ କ୍ରିମିନାଲ ଅପିଲ ବେଲ କାହିଁ ଫାଇଲ
Mohan Gagarai ta kita bad bhai.
ମୋହନ ଗାଗରେ ତା ବଡ ଭାଇ
Elder brother. He died.
ଏଇଟା
এটা হচ্ছে 9/4/24 से एक्सपायर করেছিল।
লেখা ହେଇଛି
In this connection मेरी पेश का यूडी केस यूडी केस মানে unnatural death ହେଇଛି ତାର यूडी केस ହେଇଛି has been registered on inquiry it is ascertained that Budhiya Gagarai has 4 sons या तो 4 ଭାଇ କେହି ନାହାନ୍ତି ବୋଲି ଲେଖିଛନ୍ତି ଯେ
ସରପଞ୍ଚ ଲୋକ
ହଁ ତାର 4 ଭାଇ ଅଛି
ଲେଖିବାକୁ ଲେଖି ଦେଇଥିବ ସେ ଘରେ ଆଉ କୌଣସି ପୁରୁଷ ଲୋକ ନାହାନ୍ତି
4
ସେ ଭାଇ ସବୁ ଅଲଗା ରହୁଛନ୍ତି ସେ ସରପଞ୍ଚ ଲେଖିଛି ଆପଣ ବି ତ ଜେଲରେ ଅଲଗା ରହୁଛନ୍ତି କେବେ 10 କେବେ କାଲି କାଲି ଅଛି Higher number Swanshot is an application for entering death in the ground of to perform the obsequious ceremony of his elder brother who died on 9/4/2015. Death certificate and a certificate issued by Sarpanch Yoda Block Balda Gram Panchayat Keonjhar has been annexed to the interim application, wherein it is mentioned about the death of the elder brother of the petitioner, namely Mohan Gagarai. The Land Council for the state has also produced the written instruction received from IIC Bombay Police Station, dated 17/4/2025, wherein it is mentioned that Mohan Gagarai, son of Bhia Gagarai, died on 9/4/2024, and the petitioner is the brother of the said Mohan Gagarai. The written instruction is taken on paper, considering the submission made by the Land Council for the respective parties. The Governments taken in the interim application, the document annexed thereto, and the written instruction received from the land council for the state, we are inclined to release the petition in the period of 2 weeks from the date of release. We'll file the matter be listed on such and such, file the surrender strategy. So it was security for the applied for in the course of yes.
Item 7.
I will lecture now. My daily is pending, my lord.
Your bail application has never been rejected earlier.
No, my lord. IN number 894 of 2020.
Eyewitnesses are there.
My lord.
3 eyewitnesses.
3
3, 4, and 7.
PW 3, PW 4,
And 7.
7. Eyewitnesses and doctor is
11.
11, my lord.
okay. Eyewitness of PW 3.
That was leading to discovery.
Mahusila Kanha. Kanha Kanha came with a wooden pole, assaulted on the head of Chandu. Due to the assault, Chandu fell down. Then Ranju snatched away wooden pole from the hands of Kanha, climbed on the chest of Chandu, assaulted him on his leg and other part of the body. ସେ ଦି ଜଣ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ ନା ଜଣେ?
Only Kanha has been, only the present appellant has been convicted.
She has been accused.
No. The other accused, my lord,
Ranju
was
Ranju.
granted
One
bail.
accused when
He was absconded for that reason. Trial was split up.
ଆଚ୍ଛା ତ ରଞ୍ଜୁ ନାଁରେ ଚାର୍ଜସିଟ୍ ହେଇଛି ତ?
ଚାର୍ଜସିଟ୍ ହେଇକି ସେ ଟ୍ରାଏଲ ଫେସ୍।
ଠିକ ଅଛି। ବାକି ଆପଣଙ୍କର PW 11 depressed fracture over the occipital bone,
5 injuries.
So on so. Death was due to craniocerebral injury and its complication thereof. Right shoulder area, right scapular area, left knee joint, occipital extremity, left side frontal radial. Even the Michigan merchant, या ब्लोटा होची मुंडो ब्लोटा माने वाइटल पार्ट रे जोटा की craniocerebral injury करछि बेली डॉक्टर कहउछन कोन कहउछन
सडन डेथ एंड प्रोपगेशन में लग
कोन प्रोवोकेशन
Right?
के किसी जाना पुलिस नहीं
No provision. May I place the evidence of the PW eyewitness?
PW
PW 3.
3.
I'll start with PW
see
3.
the further hearing south of Ranju.
Yes.
I came out from the house and found Ranju and Chandu are quarreling with each other.
She has seen the occurrence.
Ranju ଆଉ Chandu.
Ranju is accused.
हाँ
ये पढ़े जा सीख रिपीट ला
suddenly accused Kanha came. अच्छा से ଦି जणଙ୍କ ଭିତରେ
ये बसिकरी
ରଞ୍ଜୁଟା କଣ ପୁଅ ନା ଝିଅଟା?
ଝିଅ ସ୍ତ୍ରୀ ଲୋକ।
So चंदू सांगरे तांकर कली होतला ये हठात आसिकिनी वुडन पोल रे how this man is related to Chandu Ranju Ranju
ଗୋଟେ ବସ୍ତିରେ ଆଜ୍ଞା
तो सी तो तांको भीतर कली करथला आपन काई पाठ धरिकिन पळे आसले
प्रोवोकेशन कोठी हेला
You snatched away the wooden pole from the hand of Kanna.
हां ହେଲା
No,
प्रथम टा से
whether he is
valuation
related to any. That is why we put a question to you. Suppose she would have been in your family, this Ranju. He is no way related to you. सी तारो ex संगरे कली करथला तो आपण पळे आसी ताकू कोन पई ex को मारले और how it was grave and sudden provocation to you. You are taking a plea of grave and sudden provocation. तो बेसी वर्ष भी तो रही ना 2022 रो घटना माने 3 वर्ष तो हेनी एपर्यंत यदि केबेठु अरेस्ट हेलो
My lord, 14/9/2022, 14/9/2022.
September
how to ruin it a thousand pending thousand I reject kali
It is the answer of some of it.
run counsel for the petitioner 6 for an adjournment summer vacation for revocation. Yeah.
Item 8.
Salsa guideline अनुसार फाइल Lordship last occasion have directed the running council for the state to take inspection. That is 25/3/25.
Transfer guidelines from previous. केते बयस लिखा है तदरे
86 है
86
column number 4 shows 86
इतने जो लेडीज में कुछ दिया ही
the basis are the Aadhaar card
अच्छा मॉडल
Page 7.
कौन आसिला
And for a limited period he was on bail.
What is your instruction?
special condition ବିଷୟରେ କିଛି ଲେଖିନାହାନ୍ତି they leave it to your lordship କିନ୍ତୁ special condition ବିଷୟରେ ଯେମିତି 14A ରେ ଯୋଉଟା ଅଛି special condition ସେଇ ବିଷୟରେ କିଛି ଲେଖିନାହାନ୍ତି as I said the drive has been going on basing upon the null system
जोटा दरकार नहीं उसका अधिकार लिखाई
ये जो पार्टटा अछि हमें पढिलु पुरा जे खाली बयस हे गेला हबनी ताकू दरकार से निजे पर जाई पर नथिबो से सेही टाइप रो लोकटे हेले मेंटली ये लो ताकू ही केवल ए आसी
मिल परिबो से बेनिफिट
इट्स नॉट दैट नियरली 70 वर्ष थिबो फिट एंड फाइन थिबो तारो निजे काम निजे करूथिबो सेगुडा का आसीबनी ए टाइप
the special condition take instruction to that
सेही लाइट रे नियम इंस्ट्रक्शन এটা দিলে যে এটা জেরক্স ফাইল
letter basically
older patients with mental and physical disability are required to ensure they are not discriminated against in their access to justice and treatment in criminal justice. The release on compassionate ground older prisoners who are in need of constant specialist nursing care and who do not pose a risk to the society and transferring them so on. এই জিনিসটা দরকার আপন থ্রেট রিস্ক সোসাইটি মানে এটা আইআইসি টু নেবে আচ্ছা এই যোটা কনস্টান্ট স্পেশালিস্ট নর্সিং কেয়ার এটা আপনার জেল ডক্টর ଦେଇକିନି সুপরিটেন্ডেন্ট ফরওয়ার্ড করিবে ତେଣୁ ଏଇ ଟାଇପ ର ହେଲେ ହିଁ ସେ ଯୋଉ 70 years
Punishment
ଏଭବ ହେଲେ ତାଙ୍କୁ ଇଏ
Match.
କରାଯିବ ହେଲା ବୁଝିଲ ନା
ସେ ଫର୍ମାଟ ରେ ଆଜ୍ଞା ଦେଇଛନ୍ତି ସେଟା ଆକ୍ଟିଭ ଟ୍ରିଟମେଣ୍ଟ ହଉନି ଫର୍ମାଟ ରେ ଦେଇଛନ୍ତି
ଲେଖିବେ ତାହେଲେ ତ ହବ ନାହିଁ ତାହେଲେ ତ ନୁହେଁ ତାହେଲେ ତ ଇଜ ଫିଟ୍ ଆଣ୍ଡ ଫାଇନ୍
ତେଣୁ
ଏଇଟା ଦେଇଛନ୍ତି no ongoing medical treatment
ତାହେଲେ he is fit and fine
ତେଣୁ
he
ସେଇଥିପାଇଁ
requires a nursing ତା ମାନେ outside
ଏଇ ସ୍କିମ ଟା ହେଇଛି ଠିକ ଅଛି ବଟ ସେ ଯୋଉ ଟାଇପ ର ପର୍ପସ ପାଇଁ କରିଛନ୍ତି ଅଦରୱାଇଜ ନର୍ମାଲି ଯେମିତି ଅନ୍ୟ ମାନଙ୍କର ବେଲ କନସିଡର କରିବା କଥା ସେମିତି କରାଯିବ ଏଇଟା ଗୋଟେ ସ୍ପେଶାଲ ପ୍ରିଭିଲେଜ ଦିଆଯାଇଛି ଏଇ ମାନଙ୍କ ପାଇଁ
in most of the cases it is
ହଁ
found
ନାଇଁ
that some of the inmates require assistance they cannot even if they are given treatment in the jail it is not sufficient they require assisting hand so they need to go out
ଫ୍ୟାମିଲି ପାଖରେ ରହିଲେ
Yes.
ଯୋଉଟା ହେଇପାରିବ ଲେଖନ୍ତୁ the learning council for the state submits that even though he has received instruction as per order dated
25/3/25
25/3/2025 but that is not in consonance with the guidelines which is enumerated in the special campaign for swan soul issued by the National Legal Services Authority. And wherein it is mentioned that release on compassionate ground of older prisoners who are in need of constant specialist nursing care and who do not pose risk to the society is to be seen. And in that respect, she is not only to obtain instruction from the concerned jail superintendent, but also from the IIC of the concerned police station. Put up this matter, we commence.
I am appearing to the CRLA 516 of 2020.
Sorry,
that is bail ta sub
it is order ta dokka hochi 5th of May 2025. So this instruction is taken on record. The file instruction dated was 10/4/2025 from the so but that is not sufficient and does not meet the requirement as framed in the guidelines. The application more than
So item appearing 516 of 24 and 259 of 25. Bail appeal may be hard.
Prem Thapa.
On merit. Say dita achi like last ko dita. Bail ta take sun
Hemanto Thapa.
Prem Thapa
Prem Thapa
and Sankheswar Maji. Our 259 of the 25.
CORAM.
This is actually they were cultivating the government land. So there is a class of between the both
it's
the
a case of 5 murder.
Yes,
there are eyewitnesses to the occurrence. Why bail will be granted to you?
No, actually 4 of us also are injured, seriously injured.
So,
sir, and
is there any counter case?
No counter case because the police has not taken. That actually that's five people. 4 of us are also equally injured, and none of the actually 40 accused are there.
Mr.
But they have
Counsel, you are arguing as if it is single murder. You are forgetting that it's a case of 5 murders, and you stated to have received the injury during course of the occurrence, but there is no counter case.
So counter case to I'm sure it is a sudden provocation. It is semane chaଷ କରୁଛନ୍ତି ଏମାନେ ଚାଷ ଯାଇଛନ୍ତି ଏଟା ହେଇଛି ସେଠୁ ଏମାନେ already 12-13 ମସିହାରୁ 12 ବର୍ଷ
eyewitnesses madam
PW 13
13 ମସିହାରୁ 12 ବର୍ଷ ହେଲା ରହିଲେଣି and it is a sudden provocation ରେ ସେଟା ହେଇଛି and ସେଟା କୌଣସି assaulting ରେ ସେମାନେ chemical examination କରିନାହାନ୍ତି କି fingerprint ନେଇନାହାନ୍ତି 40 ଜଣ ଅଛନ୍ତି କିଏ କୋଉଠି ଅଛି
all the deceased had gone to butcher a land to plow the land, right? All the accused persons shouted assaulted the deceased persons by means of badi, thenga, tabli, and tangia.
Actually,
they all dealt blow of tabli and tangia to the deceased persons. When I tried to give them water, all the accused persons threatened me not to give water to them. All the deceased persons died at the spot. So, who are the doctors? PW13 is an eyewitness, and Dr.
There are several doctors. I'll place one by.
Doctors are there, and doctors have noticed that there are injuries.
There are multiple injuries.
Three injuries in each of the diseases.
And your case is that you have sustained some injuries.
Yes, my lord.
You means this petitioner, this Prem Thapa.
Sankheshwar Maji.
Sankheshwar Maji has sustained injury.
My lord.
No counter case.
No counter. No counter.
Any other point?
And actually, the disease has killed one of my son 1 year back.
How many years you are in custody?
From July 2013.
So have you got the custody certificate?
Not
Get the custody certificate and also instruction about the criminal antecedent.
Criminal antecedent.
So the land council for the
one more. That criminal appeal 506 2014 24 he is having one incident, he has got acquitted. That is 143. He is having one incident, he got acquitted in 2012.
No, we are calling about this Sankheshwar Maji. Sankheshwar Maji lekhantu IN number 534 of 2025. There is an application for bail. The Land Council for the appellant submits that the appellant is in judicial custody since 2013.
Sir, ସେଥିରେ 4 ଜଣ ଅଛନ୍ତି.
Sankheshwar Maji case.
But you are only for Sankheshwar.
bail ଟା move କରୁଛନ୍ତି ବର୍ତ୍ତମାନ 4 ଜଣ ପାଇଁ ନା ଜଣ ପାଇଁ?
4 ଜଣ.
ଆଚ୍ଛା ଦେଖି IN number IN number ଆଚ୍ଛା ହଁ ସମସ୍ତଙ୍କ ପାଇଁ so 4 appellants and they are in judicial custody since 2013.
July 2013.
Let the Land Council for the state obtain instruction regarding the criminal antecedent and also produce the custody certificate. Acha, ये जो प्रेम थापा आपण move करछन परा ना नहीं
so for Prem Thapa is concerned, I am there. He is in custody since 3/4/2014.
अच्छा एटा कर दियंतु 2014 रो अछंती custody
3/4 and he was having one incident, he got acquitted in 2012.
custody certificate ଆଉ ଗୋଟେ होची antecedent
ମୋର ବି ସେଇ ଦୁଇଟା ଅଛି
ଆପଣଙ୍କର ଆଉ କୋଉଟା
ମୋର ହଉଛି 475 478
475 ରେ ସେम ସେ କେବେଠୁ ରହିଲାଣି
ସବୁ 2013
ଆଜ୍ଞା ଏଟା 2013 custody certificate criminal antecedent सेम होची हमर हेमंत थापा 478 2024
ଆଜ୍ଞା
ସେଠି रो
ଆଉ ଯୋଉ 477 ରେ ସଦାଶିବ ମାଝୀ ତ
already ଆସିଥିଲା custody.
ଇଏରେ ମୁଭ୍ କରିଛି ଆଉ ଅଲଗା
ସେଟା ଛାଡି ଦିଅନ୍ତୁ ସେଟା
ଆଉ ଜଣେ ରହିଛି ସେଥିରେ
କୋଉଥିରେ ସଦାଶିବ ମାଝୀରେ ଆଚ୍ଛା ସେଇ ପ୍ରଥମ ଆପିଲ ଯୋଉଟା ଲେଖିଲେ ନା ତା ଦେହରେ ତା ପାଇଁ କଣ ବେଲ ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇଛି
ହଁ ସମସ୍ତଙ୍କ ପାଇଁ ଫାଇଲ ହେଇଛି
ଆଚ୍ଛା
ତାପରେ ମାର୍କଣ୍ଡ ଆଉ କାଶୀନାଥ
ଆଜ୍ଞା
ଏଇ ଯୋଉ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 and 3 ର contention लिखदेवे जो so far as appellant number 2 and 3 is concerned they are in judicial custody since 2013 state of custody certificate of criminal appeal ये केवल तार जो सदाशिव माजिटारो ये instruction टा आसी से जो स्पेशल कैंपेन ना नालसा गाइड बने yes next
ସବୁଗୁଡା 5 ତାରିଖରେ ଆସିବ
yes
my lord much obliged
next
Item 9.
item 9 I pray for a short adjournment also.
Deposition copies may be supplied so that I can ask.
The Land Council IN number so and so this is an application for bail. Land Council for the state submits that she is not having the copy of the deposition with him or with her. You supply the deposition copies to the state council. Let the Land Council for the appellant supply the deposition copies to the land council for the state. Stop. Land council for the appellant. You have got power in this case.
Yes, sir.
What is your good name?
Saswat.
S. Jena, land council appearing for the appellant. Petitioner seeks for an adjournment. Matter is adjourned. Please this matter. Please support for the Yes.
Okay.
Call the matter one by one.
Item 10.
Another mobile na 5/9/2024 reports received from the Department of the present health condition of the appellant being filed. So those were taken under non-appears for the appellant. We engage Professor Sahoo to argue the application. How ଅଛି ଠିକ ଅଛି we'll hear this matter. ବାକି ଏଇ ଯୋଉଗୁଡା ସବୁ ଗୁଡା ଲିଷ୍ଟରେ ଯୋଉ ଅଛି ତାକୁ ଦେଖି ଦେଇଛନ୍ତି କୌଣସି ଡେଥ୍ କେସ୍ ଅଛି କି ଆଉ ବାକି ଏଇ ଯୋଉ ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ 2008 ନା ମୁଁ ସେଇଥିପାଇଁ এই ମ୍ୟାଟରଟା ତ ଆମେ ଶୁଣିଦବୁ ବଟ୍ ଏଇ ଯୋଉ ଅନ୍ୟ ମ୍ୟାଟର ଗୁଡାକ ଆପଣ କାଲି ଯେମିତି ଅର୍ଡରଟେ ପାସ୍ ହେଇଥିଲା ଏ ଯୋଉ ଷ୍ଟାଟସ୍ ଅଫ ଦି ଆକ୍ୟୁଜ ତାକୁ ନିଅନ୍ତୁ ଆସିଛି ନାଇଁ ଯେ ଷ୍ଟାଟସ୍ ଆସିଥିବ ପ୍ରିଭିୟସ୍ ଅର୍ଡର ତାହେଲେ କିଛି ଦେଖିବ ନେକ୍ସଟ ଆଇଟମଟା ଦେଖିବା ମ୍ୟାଡାମ ଆପଣ ବସନ୍ତୁ ଆମ ଏଇଟା ସରିଯାଉ ତାପରେ what is the status report of one
was released on bail. As per the order of the advocates, it was released on bail.
Item 11
item number 11
तो तार whereabouts किसी जरा नहीं matter since last divorce आइलानी
After he was released on bail.
Yeah, 2016. It's an occurrence of 2006.
Right.
2016 he was allowed, he was released on bail by this honorable court. ତାପରଠୁ ଯେତେବେଳେ hearing ପାଇଁ ଉଠିଛି in the last 2-3 years 2023-22 ରୁ his whereabouts has not been ascertained. Last occasion ବି ଆସିଲା ଯେ jail ରୁ ସେ ଯାଇଛି. That was the last instruction probably.
He has been released.
He has been released on bail. କିନ୍ତୁ ତାପରଠୁ ତା ଗାଁକୁ ଫେରିନି କି ଆଉ କିଛି whereabouts ଆମ ପାଖେ ବି ନାହିଁ. But essential ଅଛି last occasion case की କରିବା
no, there is nothing. If you argue the matter
again
and if we let us say confirm, then obviously ଯେତେବେଳେ ବି ଧରା ହବ ସେ ରହିବ ଆଉ ଯଦି ନାହିଁ ତ ନାହିଁ ସେ ବେଲ୍ ବଣ୍ଡ କ୍ୟାନସଲ ହବ ସେ ଗଲା କାମ ଛିଣ୍ଡଲା ସେ ତାର
ଖାଲି ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ନ ହେଇଥିବା କଥା
ହଁ
ସେଇ ପାର୍ଟଟା ଆଇ ଥିଙ୍କ ଦେ କ୍ୟାନ୍
ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହଉ ତ ଯୋଉମାନେ ବେଲରେ ଥାନ୍ତି
ଆଉ ତା କୁଆଡେ
2016 ରୁ ତ
ଚାନ୍ସ ନାହିଁ
ପ୍ରିମ୍ୟାଚୁର
ତାଙ୍କର ଏଇଠି ନାଇଁ ଦିସ୍ ଇଜ ନଟ୍ ଦ୍ୟାଟ୍ କେସ୍
ତ ଏଇ ଦିଟା ଶୁଣି ହବ କିଛି ଅସୁବିଧା ନାହିଁ 10-11 ତାପରେ ଚାଲନ୍ତୁ ବାରକୁ ଆସନ୍ତୁ ଏଟାର ଆସିଲା କଣ
regarding the same address
ତାମାନେ ଏ ବେଲ୍
is there
ବେଲ୍ ଅଛି 2020 2020
ହଁ no
is there
and
କିନ୍ତୁ ଚିଠି ଲେଖିଥିଲି ତାକୁ 2024 14/8/2024 ରେ କିଛି ପର୍ଯ୍ୟନ୍ତ
reply ନାହିଁ but he is there
ସେଟା ଶୁଣି ହବ ତାପରେ ନେକ୍ସଟ
Last occasion, a report was called for about the juvenile.
No, about juvenile means about the juvenility of the person or what?
No, ଆଉ ଗୋଟେ
another accused.
ଠିକ ଅଛି ଏମାନଙ୍କର କଥା କଣ
ଏମାନଙ୍କର ଏମାନେ ବେଲରେ ଥିଲେ 6/3/2012
12 ରୁ
ଆଜ୍ଞା order dated 25/7/2013 ରେ ଅଛି
25 କେତେ
25/7/2023
2023 ଅଛି। ନାଇଁ 26/2013 ରେ bill ରେ appellant number 1
କିଛି 6/3/2012 ରେ on consideration of the evidence we allow the prayer for bail. Instructions for next bail. हाँ 12 ରେ
bill ଅଛନ୍ତି ମାନେ ଶୁଣି ହବ। ତାପରେ next ହେଉଛି item number 14 report received from district judge Koraput regarding the absconded body ଛାଡ଼ ଏଇଟା ଶୁଣି ହବ। next ରେ jail criminal appeal ଏଇଟା କଣ 2000 ଏଇଟା bail ଅଛି ନା ନାହିଁ item number 15 ହଁ bail ନାହିଁ ଏଇଟାରେ ଆପଣ instruction ଆଣିବେ। imprisonment for life
2006
এইটাରେ this item ଯୋଉଟା କହୁଛୁ item number 15 ନା JCRL number 10 of 2008 ହେଲା ଆଜି କାଲି ସେମିତି ଅର୍ଡର ଗୁଡାଏ ପାସ୍ ହେଇଥିଲା ଷ୍ଟାଟସ୍ ଅଫ ଦିଆଯାଇଥିଲା ଯୋଉଟା କାଲି କହିଥିଲୁ ଜାଣିଲେ ତ ଯଦି ରିଲିଜ ହେଇଥିବ ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ତାକୁ ଆଣିବେ ହେଲା ଆଉ ଦ୍ୱିତୀୟ କଥା ବଞ୍ଚିଛି କି ନାହିଁ ଆଉ ଏ ଦିଟା ନିଜର ତାପରେ ନେକ୍ସଟ ଆସନ୍ତୁ 16 ନମ୍ବର whereabouts report ଆସିଛି କଣ ଆସିଲା about current whereabouts of the yet to be received acha ଆସିନି ତ so
Opponent was on bail since 29 March 2010.
bail ଯାଇଛି apparently released on bail ହଁ whereabouts ଆମେ ଶୁଣି ଦେଇପାରୁ ଥିଲା ଏଟା କିଛି ଅସୁବିଧା ନାହିଁ next 17 ନମ୍ବର two sets of 17 ନମ୍ବର bail ଯାଇଛି କି
Bail since 2019.
4/4/2019 ରେ ଶୁଣିବ ତାପରେ next 18 ନମ୍ବର
18.
ସେଇ କରି ଯାଇଛି
19
ଛାଡ଼ ତାପରେ next 19
bail since 2018.
bail ଯାଇଛି 20
Bail since 2011.
next 21
2014 ରୁ bail ଯାଇଛି 2014 ରୁ 13/11/2014
ଠିକ ତାପରେ 22 अच्छी 9/10/2009 7/2010 रे हम तापर नेक्स्ट 23 ना 23 देखो आइटम नंबर 16/7/2014 नेक्स्ट आइटम
24 ଟା 26/11/2014 ବେଲ୍ ଅଛି।
ठीक है तापर
ଆଜ୍ଞା ଏଇଟାରେ ପେପର ବୁକ୍ କରିନାହାନ୍ତି
କୋଉଥିରେ
24 ନମ୍ବର
24 ରେ
अच्छा
हाँ पेपर
जस्ट
बुकिंग
कौन सा all right JCRL number 52 of 2008 since paper book has not been prepared the registry is directed to prepare the paper book at an earliest and the matter be placed after summer vacation. Yes, for hearing.
25 is on bail.
24 years younger.
25
25
हाँ.
wrong ठीक है
bail since 2014.
हाँ ठीक है 25 bail तापर next 26 5/1/2016 next 27
27 2011 ରୁ ବେଲ୍ ଅଛି।
ठीक है ना 28
28 my lord praying for certain
wrong no
on behalf of Mr. Subhash Chandra
please wait कौन पे हम जानी पारना थी कौन हम खोजुचु कौन चाहूं बेल अछि 18/12/2024 ठीक है बट एठी गोटे केवल जन को दिया है बेल अप्लायंट नंबर 1 केते जन अप्लायंट किया जाए माने ये फाइल करथिला कि
ଏଇଟା ଆଉ ଜଣେ ରାମଚନ୍ଦ୍ର ସାହୁ ଅଛି
रामचंद्र प्रसन्न प्रधान
प्रशांत इज ऑन बेल रामचंद्र ଆଗରୁ ଯାଇଛି
रामचंद्र सेपरेट क्रिमिनल अपील रेगुलर अपील अछि से छाड़ो क्रिमिनल अपील 40 रे जाई छी बेल ले जाई छी त तोलर
yes yes sir since 2008 12
ठीक है चलो नेक्स्ट 29
bail since 31/8/2012
12
yes
yes next 30
on bail since 2015
2015
4/5/2015 order number 3
just a minute yes next 31
and criminal appeal number 322 of 2010 minor Pramod Kumar Das. He is in bail since
2012 18/1/2012 order number 2
चलो ठीक है 88 रे बेल है 2012 रु आउ 443 bail has been allowed in 2011. And in your case, bail has been granted.
2011.
Sure.
21/11/2011.
Okay. Next, item number 32. Yes, that is 2011.
11.
Next.
Bail since 2014.
14.
23/6/2014.
23/6/2014. Yes, next. ରିପୋର୍ଟ ହଉଛି 2023 ର। ନୂଆ ମ୍ୟାଟର। ଏଇଟା କଣ ପାଇଁ ଲିଷ୍ଟରେ ନିଆଗଲା? ମୁଁ କହିଥିଲି 2008 ରେ ଆଣିବାକୁ। ଲାଷ୍ଟ ମ୍ୟାଟର।
Engaged as the amicus matter.
अच्छा।
The bail application is not completed.
As amicus query.
Amicus query cannot be.
Practice.
That year of practice may be.
How many years?
5 years.
5 years तो बनी 10 वर्ष दरकार। और एक इंग्लिश कर दे, सारा इंग्लिश कर दे। So now we can take off this item numbers, except I think this list item number 15 to छाड़ी देले हमें जोटा रे instruction short for कलु है ना बाकी सब गुड़ा को take off हेई परियो। तो ना आउट गुड़ा 24 टा नहीं again sir।
24 पेपर।
हाँ पेपर ठीक है हाँ ये दिरा जाको बाहर कर देवे लिस्ट को अब बाकी तो सबू आसीबो ये रे
That will engage.
34 चार ढकी दे सर। So you are ready, Madam Sahu? What is this case?
The case even converted to the
Case based on direct evidence or circumstantial evidence?
medical evidence. Upon medical evidence.
Medical evidence?
Direct evidence or circumstantial evidence? Circumstantial evidence. What are the circumstances? Last scene only. Achha.
Coupled with medical.
Just a minute. Last scene is the only evidence, no other evidence. Extrajudicial confession,
leading to discovery,
leading
nothing.
to discovery 9. Last scene केबे हला डेट केबे और के दिन पर डेड बॉडी मिलना
Same day.
same day
Same day.
ये कौन सी last scene विच
Last thing is
who is the witness?
friend of the deceased.
PW.
PW.
PW2. Where they were last seen and when where the dead body was found?
Last seen about 12 noon and the dead body found
3:30.
At their very place?
No.
Huh? Some other place?
Forest.
What is the distance between the place where they were last seen and
Last seen in mid of the forest and dead body found inside his house.
so no motive has been proved?
No motivation.
Come to that PW2 evidence. Let us see.
PW2 at page 23.
Please read it out.
I know the accused, who is my neighbor. I know the deceased Mona, who died about 8 months back. On the date of occurrence, myself and Mona had been to forest to collect candy leaves in the morning. At about 12 noon, the accused came to forest and quarreled with Mona and took her to the village. I returned from forest at about 3:30 p.m. By that time, Mona was dead. I saw accused at about 4 p.m. He had not told me anything. I was examined by police. At cross-examination, she states that only road intervenes between my house and house of the accused. Jyotia Mohana is the nearest neighbor to the house of the accused. Mother, sister, two sons of Lochan is the accused, were living in the house. All the villagers used to visit the house of the accused Lochan. They lived happily. I do not know the cause of death. It is not a fact that Mona died due to poisoning and I am deposing falsely.
What is the relationship between this deceased Mona and the accused?
Husband and wife.
If this evidence is accepted, PW2's evidence, because nothing has been brought out in the cross-examination, then you were seen with your wife and took her to the village. She has stated, of course, towards the village. And then at about 12 noon, then
she was found dead in the home, in his house.
Was a মানে ডেড বডিটা କୋଉଠି ମିଳିଲା? ଓ ଘରୁ ମିଳିଲା, ଆଉ କୋଉ ଫରେଷ୍ଟ ରୁ? ଓ ତାମାନେ ଆପଣଙ୍କ ଘରୁ ଡେଡ ବଡି ମିଳିଛି ଆପଣଙ୍କ ସ୍ତ୍ରୀର? What is your statement, 313 statement? ସବୁ ମିଛ ନାହିଁ?
ନାହିଁ ନାହିଁ।
12ଟା ବେଳେ ଆପଣ ସ୍ତ୍ରୀଙ୍କ ସହିତ ଆପଣଙ୍କ ଗାଁକୁ ଫେରିଲେ, ତାପରେ ଆପଣଙ୍କ ସ୍ତ୍ରୀର ଡେଡ ବଡି ସେଇଦିନ ପାଖାପାଖି 4ଟା ବେଳେ ଆପଣଙ୍କ ଘରୁ ମିଳୁଛି। So you have not offered any explanation. And the doctor stated about the homicidal death.
Yes, ma'am.
Who is the doctor?
Dr. PW5. So it was 26.
Lacerated wound, so on. And what about your presence? ଆପଣଙ୍କୁ ସବୁ ମନା କରିଦେଇ ଚାଲିଗଲେ, ଆଉ କେହି ଦେଖି ନାହାନ୍ତି ପାଖ ପଡୋଶୀ ଲୋକ କିଛି?
PW1 is the mother of the accused. She is deceased. She said that in the previous night she had met in the morning. She, along with the mother of the accused, had been to forest to collect leaves. And there the mother of the accused disclosed about the quarrel between the husband and wife in the previous night. And when she returned from the forest, her daughter had already died. The accused, though was present in the house, had not stated anything to her.
You are also, if this evidence is taken, you are also present in the house.
I saw Lochan. Even 3 also says that you were presented.
Mauna married to the accused out of their own accord about 3 years back. They blessed with 2 sons, lived happily.
That is what I said.
PW3.
And the mother of the reproduction used to stay in another one. When I died afterwards, and I saw her dead body.
No, that is what I said. No? He also saw Lochan at this spot.
Even after the dead body was found, you were only present in the house. That is stated by PW1, the mother of the deceased. So not only you were in the company of the deceased at 12 noon and took her to the village, but also the dead body of the deceased was found in your house, and it was a case of homicidal death, and you were present in the house. So all these are very clinching evidence against you, and you have offered no explanation whatsoever in the 313 statement. How the London trial court has dealt with it?
This same evidence is also considered 1, 3, PW1, 2, and 3.
Throttling case, homicidal death. ସିଏ ଗୋଟେ ପ୍ଲି ନଉଛି ଯେ ଯୋଉ ପଏଜନିଂ ପଏଜନ ତ କିଛି ନାହିଁ
106 evidence act.
Yes.
It is 29. That is the deposition of PW6, who is the ASI of concerned police station. At the cross-examination, he had stated that I have not noticed any injury on the dead body at the time of inquest.
No, that is not.
I noted in my report that the death was due to poisoning.
No, who is he?
ASI.
ASI.
ASI for what? Can it supersede the medical evidence? What is he? What for he was engaged?
Inquest.
Inquest is a apparent cause of death. How can he say about the
exhibit of Hercules? Inquest ta kete mark heichi? Trial court report. Sure. ମୁତପିଙ୍କୁ ସୁଆଂଶ ବାସଭବନ ମୁଣ୍ଡ ଉପରୁ କରି ଏମିତି ଚିଟ୍ କରି ମରି ପଡିଥିବାର ପାୟାଗଲା। ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଓଲଟା ପଲଟା କରିବାରେ ଦୁଇ ହାତ ଅଧା ମୁଠା କରି ଛାତି ପାଖ ଶୁଣାଂଶ ରକ୍ତ ମଳଦ୍ୱାର ମୁଠା ଗୋଟେ କଳା ଚେକ୍ ଶାଢୀ ପିନ୍ଧିଥାଏ ଗୋଟେ ଜାମୁ କଲର ଶୁଣାଂଶ ପିନ୍ଧିଥାଏ। ମୃତ୍ୟୁର କାରଣ କିଛି ଜାଣି ନାହିଁ କିନ୍ତୁ କୌଣସି ସନ୍ଦେହ ନାହିଁ। Cause of death was reported to be suicidal poisoning. This is just an opinion, sir. ये आइटम नंबर जो पीएम डॉक्टर देखौची ये जो आइदर साइड ऑफ द ईयर ब्रुइजेस थिला है ना और डिसेक्शन ने देखा गला जे mucous membrane so that the hemorrhagic swan show carotid cartilage रे upper three tracheal ring fracture congested and blood fell inside it, which is antemortem in nature. So, ଏଇଥିପାଇଁ ସେ opinion ଦିଆହେଇଛି that it is a case of throttling. Throttling means pressure of the hand or pressure दियाहेइछि कौनसी ligature नहीं. The fingernails may be or may not be in case of throttling. Yes.
In case of throttling, the depressed mark of thumb will appear, but in this case, there is no thumb mark.
The question in this case, the strangulation was from front side. And paragraph number 4, I was confirmed that the death was due to throttling. And viscera was preserved to ascertain any further poisoning can cause asphyxia.
No, that is a suggestion.
Suggestion has been given, but it is not a fact that my finding is erroneous. So, ଆଉ କିଛି ନାହିଁ କଣ କହିବେ?
There is a difference between postmortem report and
Postmortem
inquest report.
Inquest report छाड़ दिया से inquest report is prepared by the ASI and some persons are villagers, they have also put their signature. ସେମାନେ କହିଲେ ଯେ ମୃତକର କଣ ପାଇଁ କାରଣ ହେଇଛି କିଛି ଜଣା ପଡୁନି ये ASI ଲେଖିଦେଲା ଯେ ଏଇଟା ହଉଛି ମାନେ ପୁରା एकदम 100% sure the cause of death of the deceased is reported due to suicidal poisoning, but the final opinion can be obtained from PM doctor. अच्छा ସେମାନେ ତ କହିଲେ ଜଣା ପଡୁନି ସେମାନେ କେତେବେଳେ କହିଲେ suicidal poisoning ସେମାନେ କହିଥାନ୍ତେ ଏଇଟା ଲେଖା ହେଇଥାନ୍ତା 9 ନମ୍ବର କଲମରେ ଯେ ଆମେ ସନ୍ଦେହ କରୁଛୁ ଯେ ସେ ବୋଧେ ବିଷ ଖାଇ ମରିଛି एकथा तो लिखा ही नहीं कॉलम नंबर 9 रे ये 10 नंबर केमती लिख देले जे रिपोर्टेड ड्यू टू सुइसाइडल पॉइजनिंग ये कॉन्ट्राडिक्ट करछि दी
कौन से यार रिपोर्टेड बोली कहारी नहीं तो रिपोर्ट ना एफआईआर ना कौन सी.
So that is not a ground to disbelieve the doctor. Doctor evidence is very consistent and you have also put a suggestion to him that your report is not perfect, but he has stick to his report. Mr. Pradhan, कौन कहिबे?
para 10 କଣ?
वो କାହାର କହୁଥିଲେ para 10?
Para 10 of the judgment.
ହଁ କଣ ସେ ଡିଲ୍ କରିଛନ୍ତି?
No, no. PW3 deposed that Lochan and deceased were living in one room, and her mother and sister were living in another room. And she saw the dead body in the room of the accused, and that is there. PW3 has stated so. What is the analysis of the court? Yes. There is no evidence that anybody else was there in between, except the appellant.
Jail Criminal Appeal number 1 of 2008. The appellant Lucian Maharana faced trial in the court of London Sessions Judge Keunjhar in Sessions Trial number 160 of 2006 for offences punishable under section 302 and 201 of the Indian Penal Code on the accusation that on 18th May 2006 at about 11 a.m. at village Dondo Senakosi, he committed murder of his wife Mouna Maharana. And was certain evidence connected to the said offense to disappear. The London Trial Court, by judgment and order dated 17/5/2007, found no evidence against the appellant so far as the charge under section 201 of the Indian Penal Code is concerned, and accordingly acquitted him of such charge. However, found the appellant guilty under section 302 of the Indian Penal Code and sentenced him to undergo imprisonment for life. The first information report was lodged by Dasarathi Nag, SI of Police, who is also the officer in charge of Pondapada Police Station.
In connection with UD case. Initially in connection with UD case.
Pandapada PSUD case number 6 dated 18/5/2006 was registered basing on the information of Lochano Maharana bracket appellant, wherein it is stated that on 18/5/2006 at about 11 a.m., when he returned from his work and asked the deceased to give rise to it, he found her dead. But found her dead. He asked the deceased to give him rise to it, but found her dead. And accordingly, he reported, and accordingly, he called the neighbors and reported, called the neighbors. During course of inquiry of the UD case by the ASI GD Dalai, as per the direction of the informant, inquest was held for the dead body of the deceased and it was sent for post-mortem examination, and then the informant took charge of the inquiry. During course of inquiry, he received the post-mortem report where the doctors opined that there were bleeding from so and so कर देवे, जहाँ लिखा है लिख देवे, and basing on the opinion, the cause, basing on the above finding, the cause of death has been opined to be asphyxia due to throttling. Accordingly, the informant lodged the first information report against the appellant who have committed the murder of the deceased. On the basis of such first information report, Pandapada PS case number 40 dated 25/6/2006 was registered under section 302(201) of the Indian Penal Code, and PW7 says Dasarathi Nag upar likhchen PW7 likh de. Himself took up the investigation. During course of investigation, he visited the spot, examined the witnesses, arrested the appellant on 26/6/2006, seized his wearing apparels under seizure list exhibit 6, collected the blood sample and nail clippings, and forwarded the appellant to court. Send the dead body to. And the nail clippings and blood samples, etc., were seized as per seizure list exhibit 7, and on his transfer, the charge of investigation was handed over to Somnath Jena, Sub-Inspector of Police, who sent the exhibits to State Forensic Science Laboratory, Rasulgarh, Bhubaneswar, through court and received the C report under Exhibit 9, and on conclusion of investigation, charge sheet was submitted under Section 302 by 201 of the Indian Penal Code against the appellant. After submission of charge sheet, the case was committed to the Court of Sessions after following due procedure, where the learned trial court framed the charges. The appellant pleaded not guilty and claimed to be trial. In order to prove its case, the prosecution examined 7 witnesses. The prosecution also exhibited 10 documents. The defense plea of the appellant is one of denial. The learned trial court, after assessing the evidence of the witnesses, came to hold that from the evidence of PW2 as well as PW3, it appears that the petitioner, the appellant, was in the company of the deceased in his house where the dead body was found, but the appellant had not offered any explanation in his statement recorded under Section 313 CRPC, which proves the guilt of the appellant. The learned trial court further held that the doctor has noticed 3 injuries on the body of the deceased and opined the death to be due to throttling. However, since none of the witnesses deposed that the appellant did anything to destroy the evidence, the learned trial court acquitted him of the charge under Section 201 IPC. However, found him guilty under Section 302 of the Indian Penal Code. Ms. S.K.Sahoo Hon'Ble, amicus curiae, appearing for the appellant, argued that since there is no direct evidence in the case and the case is based on circumstantial evidence, and in a case based on circumstantial evidence, motive assumes pertinent significance, and the prosecution has failed to establish any motive on the part of the appellant to commit the murder of the deceased, and the evidence of PW2 and PW3 only states about the larceny, on the basis of such evidence, the learned trial court should not have held the appellant guilty merely because the appellant has not offered any explanation in his statement recorded under section 313 CRPC. And it cannot be said that the chain of circumstance is so complete to unerringly point towards the guilt of the appellant, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Land counsel for the state, he further submits, argued that the inquest report indicates that it was a case of suicidal poisoning, which goes to contrary to the post-mortem report finding, and therefore benefit of doubt should be shown. Land counsel for the state, on the other hand, submitted that PW2 has specifically stated that the appellant took the deceased towards the village on the date of occurrence at about 12 noon, and when he returned from the forest at about 3:30 p.m., the dead body of the deceased was found. Similarly, PW3 has also stated that the dead body of the deceased was found in the room where she was staying with the appellant, and the appellant was present at the spot, and the doctor has noticed injuries on the person of the deceased, and specifically opined that the cause of death was asphyxia due to throttling, and when the appellant was in the company of the deceased and the occurrence took place inside the room where both of them were staying, and it was a case of homicidal death, in view of section 106 of the Evidence Act, it was required on the part of the petitioner to offer explanation as to how the deceased died. Having failed to establish the same, the London Trial Court has rightly applied such provision and came to hold that the appellant is responsible for the death of deceased, and accordingly convicted him under section 302 of the Indian Penal Code. Adverting to the contention raised by the land counsel for the respective parties, there is no dispute that the inquest over the dead body has been conducted by PW6, who was the ASI of police attached to Pandapada police station, in the Pandapada UD case number 6 of 2006 on 18/5/2006. On perusal of the inquest report under Exhibit 3, we find that in the column number 9, the opinion of the witnesses as to the cause of death has been mentioned, wherein it is stated that the exact cause is not known, and number of witnesses are signed below it. However, in column number 10, where opinion of police officer as to the cause of death is mentioned, is required to be mentioned, comma, it is stated that the cause of death of the deceased was reported due to suicidal poisoning, however, the final opinion is to be obtained from the post-mortem report. There is nothing as to who reported to the ASI at the time of inquest that the cause of death of the deceased was suicidal poisoning. Therefore, we cannot give much importance on this opinion which is mentioned in column number 10, more particularly when the doctor bracket PW5 who has conducted post-mortem examination on 19/5/2006 in the district headquarters hospital noticed number of injuries on the person of the deceased, including fracture of the tracheal ring, which was antemortem in nature, fracture of carotid cartilage and upper 3 tracheal ring, and opined the cause of death due to asphyxia due to throttling. The doctor has specifically stated that in the cross-examination that throttling means by pressing by hand, and in the case the strangulation was from the front side. And he denied the suggestion given by the London Defense Counsel that his finding is erroneous, rather confirmed that the death was due to throttling. Therefore, on the basis of the evidence of PW5, we are of the view that the London Trial Court has rightly come to the conclusion that the deceased died due to throttling. Stop. Now coming to the evidence of the other witnesses, we find that PW2 Padmini Maharana has stated that she, along with the deceased, had been to forest to collect kendu leaves in the morning hours on the date of occurrence. And she is a neighbor of the appellant, and further stated that at about 12 noon, the appellant came to the forest, quarreled with the deceased, and took her to the village. She further stated that when she returned from the forest at about 3:30 p.m., by that time the deceased was dead, and she saw the appellant at about 4 p.m. Nothing has been elicited in the cross-examination to disbelieve this last in evidence which is adduced by this witness, though suggestion has been given to PW2 that the deceased died due to poisoning, but she has denied such suggestion. PW3 has stated that the appellant and the deceased used to stay in one room, and the mother and the sister of the appellant used to stay in another room, and when he saw the dead body of the deceased in the room, at that point of time, the appellant was also present at the spot. PW1, who is the mother of the deceased, has stated that the appellant used to quarrel with the deceased and assault her. And she had been to forest to collect leaves, and when she returned from the forest at about 3 p.m., by that time the deceased was dead and the appellant was present in the house. Therefore, from the evidence of these three witnesses, that is PW1, 2, and 3, it appears that the appellant brought the deceased to the village from the forest at about 12 noon. And he was present in the house where the dead body was found. Dead body of the deceased was found at about 3:30 p.m. and it is a case of homicidal death. The appellant reported the matter in the police station, but during UD case inquiry, it was found that it is a case of homicidal death. And accordingly, the first information report was lost. As rightly held by the Lenin trial court, that in the 313 CRPC statement, the appellant has not offered any explanation as to how the deceased died a homicidal death when he was in her company. 106 of the Evidence Act deals with burden of proving the fact, especially within the knowledge. And this section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. Where the prosecution has succeeded in proving the facts from which reasonable inference can be drawn regarding the existence of certain other facts, unless the accused, by use of his special knowledge regarding such facts, failed to offer any explanation, which might drive the court to draw a different inference. If the explanation offered by the accused shows reasonable doubt on the prosecution story, he would be entitled to an acquittal. Thus, the prosecution, thus in view of Section 106 of the Evidence Act, the prosecution has to lead evidence to substantiate its accusations, if facts within the spatial knowledge of the accused are not satisfactorily explained, it is a factor against the accused. When the crime was committed inside a house, the initial burden is no doubt on the prosecution to establish its case. But the nature and amount of evidence to be laid by it to establish the charge cannot be of the same degree as required in case of circumstantial evidence. The burden would be comparatively lighter character. And in view of Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give a cogent explanation as to how the crime was committed. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that burden to establish its case lies entirely upon the prosecution, and there is no duty at all on an accused to offer an explanation. In the case in hand, since the dead body was found in the room where the appellant and the deceased were staying, and it is a case of homicidal death, the appellant was last seen with the deceased prior to the occurrence, also after the occurrence, and no explanation has been offered in the 313 statement, CRPC statement. We are of the view that in view of the circumstantial evidence appearing on record, it can be said that the chain is complete and there is no escape from the conclusion that the crime was committed by the appellant. And therefore, the learned trial court has rightly found the appellant guilty under section 302 IPC, and therefore the jail criminal appeal being devoid of merits stand dismissed. You are on bail, the appellant. देखिए jail criminal. Yes, the appellant was directed to be released on bail as per order dated 18/2/2018. He shall surrender custody forthwith, failing which the London trial court shall take appropriate steps for his arrest and to remand him in custody. Put a note of appreciation on both the counsel and 10,000 to be paid to the London amicus curiae as solved.
Another prayer.
Yes.
According to PW1 and PW2, the deceased and the accused have two sons, minor
Achha,
sons.
got a line लिख दिया The so far as the motive part is concerned, the appellant, the witnesses have stated that the PW1 has stated
Paragraph
that
2. Paragraph 2 and second line, they placed with two sons.
Appellant, the deceased married the appellant out of her own accord about 3 years back, and they were blessed with two sons, and they lived together. And
PW2
and PW2
in her cross-examination, line
2
3.
In her cross-examination,
Line 3.
as stated
That Jatiamarana is nearest to the house. The accused mother, sister, two sons of Lochan were living in the house.
That the appellant was living happily with the deceased. Anything stated by PW3?
No.
No.
So,
the PW3 has also stated that the appellant and the deceased were living happily. And the appellant brought the deceased to the hospital in a jeep. Even though the prosecution has not proved any such motive behind the crime, but in view of the available material on record, we are of the view that we'll formulate it finally.
I'm sorry, Mother.
Yes.
These two minor children have not extended any financial help, as their mother is deceased and their father is life convict. So
No, there is a victim compensation scheme is there.
Scheme is not
So
extended to this two.
in the judgment there is nothing.
Yes, no, there is nothing.
No, the judgment is of
କୋଉ ବର୍ଷର ଏଇଟା judgment?
2008.
8 ର କଣ ଥିଲା victim compensation scheme କେବେ ଆସିଲା?
ସେଟା 457 ରେ ସେଟା କେତେ 457 ରେ ସେତେବେଳେ ଥିଲେ ଆଉ ତ କିଛି ନଥିଲା. Victim compensation has come later. By then this provision was not there.
Victim compensation scheme ଟା ଆସିଲା ବୋଧେ 2013 କି କଣ, ତାପରେ amendment ହେଇଛି 2018. ଦେଖିଛନ୍ତି ଏକ୍ସାମିନ କରିଛନ୍ତି victim compensation scheme କେବେ ଆସିଲା?
ଆସିନଥିଲା
2000 ଏଟା ହଉଛି 2006-07 ର ଘଟଣା. ବର୍ତ୍ତମାନ ତ ପୁରା ରେଗୁଲାରାଇଜ ହେଇକି ଦିଆ ହଉଛି କାମ.